Mr. Simpson is present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Ullman, Mr. Blazier, and Mr. Neufeld. People represented by Ms. Clark, Mr. Goldberg, Mr. Darden. Jury is not present, and the jury is up in the holding lounge upstairs. And I recollect that I saw Michelle Kessler this morning come in with a city attorney. All right. All right, Mr. Cochran.
Good morning, Judge Ito.
Good morning, sir.
Your Honor, one matter I wanted to bring to the court's attention and perhaps get some clarification. Yesterday, the court asked Ms. Clark whether or not she could establish a foundation, as I recall it, for some alleged videos of our client with gloves, which we had seen in the past. And Ms. Clark smiled at Your Honor and said, absolutely. And we were informed that yesterday, after court, Suzanne Childs of the District Attorney's Office called various members of the media that said Ms. Clark had been misquoted or had been misunderstood regarding their ability to lay a foundation regarding these items. And as officers of the court, I'm just rising to try to get a clarification of what is true and what was meant by what Ms. Clark said. If there's some misunderstanding, we have a right to know that, and we want to know exactly, and you have a right, obviously, to know what was meant. If they're backing off, you read the LA Times today, you'll see some mention of that, I think. And I know that's, forgive me, I forgot who I was talking to. You have not read the LA Times, right? But anyway, Your Honor, I think
No,
this
it's not out of disrespect for the LA Times, but I found that it's not helpful for me to read news media reports of this case because I don't want to be influenced by any of them.
And I understand, Your Honor, certainly. I think we share that view on occasion ourselves. Your Honor, but at any rate, I rise to ask for clarification of whether Ms. Clark is saying she can lay a foundation that these gloves were similar, or these the exact same gloves. The information we got, and much of the media got, well, these were going to be the same gloves, and we know that's not true, so I think we should have some clarification of that, and I want to do that early on.
All right. Good morning, Ms. Clark.
Good morning, Your Honor. I don't try my case in the press, and I don't read the papers to see how I should respond to counsel in court. I think it was very clear to the court what was meant, what I said, and I think that's all that matters. What the LA Times thinks about what I said, or any other reporter, is irrelevant to me. The court understood me. The court questioned us at sidebar. I don't think there's any misunderstanding between the court and myself or counsel, and I don't think any further clarification is required.
We did discuss this matter twice, once in open court and once at the sidebar. And at the sidebar, my recollection is that we discussed the nature of the stitching and a few other.
Well, if I might.
And may I add one more thing? Yeah, just a minute.
Yes.
Sure. One more thing is that whether or not counsel puts in the glove drying experiment, the people's position is that those gloves and those photographs photographs of Mr. Simpson wearing those gloves will be relevant on rebuttal, regardless of what the defense does with respect to experiments or not, because they are relevant to disprove the conspiracy theory. There are many reasons why those glove photographs will come in rebuttal, we believe, regardless of whether or not they come in during the defense case. This was simply one chance to put them in during the defense case. There may be others, but if there are not, on rebuttal to refute the conspiracy theme and to refute the planting theme that the defense has throughout carried in this case, I think
So
they are.
I take it the bottom line, Ms. Clark, is that you stand by your statements on the record of yesterday.
Yes, Your Honor, I do.
Well, that's fine then, because the only thing I want to point out, when Suzanne Childs, who represents that office, makes calls saying she was misquoted, I think we have a right to inquire upon that, and that's all we've done, Your Honor.
I understand that.
We vigorously dispute that. They will never be able to prove these gloves, that our client wore those gloves, and you'll see. And then the last thing I'd like to say is that we've opened no doors on this. If they had this information, Judge, they would have put it in their case in chief. They didn't, and we'll vigorously oppose any attempt and rebuttal at that time.
All right,
Thank
and
you.
just for counsel's information, late yesterday I received from the FBI a package of photographs and videotapes regarding shoes and gloves that my staff is cataloging right now and will make available to you
Thank you.
later this morning.
Thank you.
All right, let's proceed to the Michelle Kessler issue. My understanding is the defendant wishes to call Ms. Kessler to testify first to the normal things, that she's the lab director, that she did participate in the inventorying of some of the all of the evidence that was in possession of the LAPD at a certain point in time, did other things with regards to the physical evidence itself, and then there are the other issues regarding leaks of information. All right, so those two general areas, I understand, is what we're going to inquire into. Is that correct? Mr. Neufeld, are you going to handle this?
Yes, Your Honor. I don't even intend to spend that much time on her inventorying and things like that. I'm going to focus much more on access to information, what the security system was at LAPD for handling the information in this case, and what her role was in that, and how that relates to the leaks. I'm going to make it, I think, even more focused.
All right, well, this is a 402 hearing.
Right.
All right. And I understand we have counsel from the city attorney's office.
Yes, good morning, Your Honor. Arthur Walsh, Assistant City Attorney, here on behalf of Ms. Kessler.
All right, Mr. Walsh, have you had the opportunity to consult with defense counsel regarding their reasons for asking for this 402 hearing this morning?
No, Your Honor, I have not.
All right. Do you have any comment, or have you discussed this with the district attorney's office?
I understand, both from talking to the district attorney and from general press reports, that what the scope of this is intended to be. And I, at present, have no objection to questions directed to the witness regarding her own personal knowledge of these matters. However, should questions intrude into her knowledge of any internal affairs investigation or any matter relating to personnel records of police department employees, I will make appropriate objections at that time.
All right, then the court will note your presence for the record, and you may rise to assert any objections at a time you feel appropriate.
Thank you, Your Honor.
All right. And Ms. Kessler, what are your time constraints this morning?
I need to leave by 10.
Okay, well, let's get started.
Your Honor, for the record, as the court knows, we did object to this procedure, given that there's no offer of proof. And in a 402 hearing, you do not necessarily have to call live witnesses, since it's merely a pretrial ruling of how the court would later rule at the trial itself.
Mm-hmm. All right. Your objection's noted for the record. Thank you.
Your Honor, did Ms. Kessler say she has to leave by, what time did she say? I missed
10 o'clock.
10 o'clock. Thank you.
All right. Mrs. Robertson.
You solemnly swear that the testimony you may give in the trial is not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat on the witness stand and state and spell your first and last names for the record.
Michelle Kessler, M-I-C-H-E-L-E, K-E-S-T-L-E-R.
Mr. Neufeld.
Thank you. Good morning, Ms. Kessler.
Morning.
Ms. Kessler, what is your current title?
Currently, I am the Laboratory Director, Chief Forensic Chemist for the Los Angeles Police Department.
And as of June 12, 1994, what was your title?
I was the Assistant Lab Director, or one of the Assistant Lab Directors for the Los Angeles Police Department Crime Laboratory.
And when did your title change?
Sometime in July, I don't recall the date.
Sometime July of 1994?
That's correct.
Now, as the laboratory director, do you have, and before that as the assistant laboratory director, do you have some day-to-day management responsibilities for the various units within SID?
Yes, I do.
And during that time period frame from June of 1994 to the present, was it also your practice to, on occasion, take responsibility for managing some of the larger cases?
Manager, more oversee, not necessarily manage, oversee and stay involved and help cause them to proceed at a somewhat normal pace as opposed to helter-skelter.
Okay, and in this particular case, did you play a role in overseeing the processing and handling of this case?
I was attempting to assist in that process because at that time, Mr. Matheson, there was no other assistant lab director, so I played a little larger role than I normally would.
Well, for instance, you were contacted by the police as early as June 13th at your home to be informed about what was going on. Isn't that right?
Just to tell me that a large case had taken place.
And you had meetings shortly after that on June 15th with Marcia Clark and other people about the processing and handling of evidence, didn't you?
This is not relevant to the 402 issues, Your Honor.
Not real relevant, counsel. We're talking about September issues.
All right. Well, Ms. Kessler, this case was given a special designation of a confidential case, was it not?
Yes.
Okay. And as a confidential case, are certain different procedures set up to maintain security of the testing of evidence and for the results of the testing of evidence?
The testing of evidence, and not sure I understand your question. I can answer half, and then I'm not sure that's
All right.
answering all of it. As for the testing of evidence, no, the testing is still done under the same process.
All right. What about the dissemination of test results and information? Is it shared differently in a case once it's been designated confidential?
Well, we normally, the laboratory only shares the results with the investigating officers and with the prosecutorial agency. That doesn't change either, other than the results are held in a separate secured area, usually a supervisor's office, file cabinet, someplace, until such time as it's over.
And in this case, is that the procedure that was utilized?
Yes.
Now, when you say that the test results are shared only with certain select people, in this particular case, who were those people, first of all, at SID, with whom the test results would be shared with?
All right, why don't we rephrase that question because it's vague.
Okay?
We're talking about a certain set of test results here.
All right, let me back up one step. All right. Were you also designated as the laboratory director to be the point person at SID, to be the recipient of reports governing test results in this case that were mailed to SID from outside agencies?
That is, I'm always the point person for all test results, only because they are addressed to me so that they don't go to the bomb squad or some other portion of SID who would know not what to do with them.
For instance, you had test results mailed to you, in this case, from the Federal Bureau of Investigation. Is that right?
Well, it's vague as to whether she physically received these or they were just addressed to
Saying
her.
rephrase the question.
Were the results that came from the FBI addressed to you, Michelle Kessler, at the SID laboratory?
It's unclear to me. I don't recall whether we actually received them directly in the laboratory or whether they went to the court at that time. I've forgotten.
Let me just see if this refreshes your recollection.
Counsel, I'm going to sustain the court's own objection. I'm not interested in this.
I think, Your Honor, it's going to become very, very relevant in about 5 minutes.
Nope. We're talking Cellmark here, and we're not talking FBI.
All right, I can even explain it in front of, there's no problem, Your Honor. The issue is that at the same time that the report was received from Cellmark, they also received a report from the FBI regarding the hair and fiber analysis,
It's irrelevant.
which was also leaked to the press the same day.
It's irrelevant.
Okay.
The only thing I'm interested in is whether or not
All right.
the Cellmark results.
Fine. All right. Have you seen a report from Cellmark Laboratory dated September 8th, 1994, that was faxed to Michelle Kessler at the SID Laboratory on September 12th, 1994?
Objection vague at the time.
Oh, well.
I saw a report dated September 8th, a hard copy of that report, that it sometime was faxed, but it was not faxed to me. It's addressed to me. I do not know what the cover fax, who the fax was sent to, or when.
You don't know to whom this was faxed?
No, again, my name is on the header, but I don't know what the fax cover sheet would have said, nor did I ever see it.
Your Honor, at this time, I would like to introduce, for the record, for the court's consideration of these issues, a 1, 2, 3, 4, 5-page report from Cellmark, which is a report dated September 8th, supplying results of DNA testing on the Bundy drops, with a fax from Cellmark of September 12th, 1994.
And does this document have the imprint of the number that it was faxed to?
No, it has just the imprint that it was where it was faxed from, that I see on this particular sheet. The copy that we were provided by the prosecution in discovery says where it was faxed from on September 12th, 1994. It's addressed to Michelle Kessler at the Los Angeles Police Department. What we also have in conjunction with this, which we received in discovery, and I'd like to introduce it at the same time, because it came at the same time as part of the same discovery, was a cover sheet from the Los Angeles Police Department Scientific Investigation Division of a fax from Michelle Kessler to Marcia Clark at the Los Angeles County District Attorney's Office, dated September 16, 1994. In other words, we only received a copy
Okay.
that the district attorney received.
Mrs. Robertson, what is the next in order for defense exhibits? All right, the Cellmark report of dated September 8th, addressed to Ms. Kessler, will be 1281, and 1282 will be the fax of Ms. Kessler to Ms. Clark.
Your Honor, I wonder if I might have the opportunity to review these. I haven't seen them.
All right, Mrs. Robertson, would you have the staff make copies for everybody, please? It would speed things up in the future if you're going to use documents that we have multiple copies available.
I apologize, Your Honor.
All right. All right, proceed, counsel.
Well, I want to just show her a copy of that document to see if it refreshes her recollection as to a report that she did, in fact, see from Cellmark Diagnostics. But,
Well, she's testified she saw it.
okay. All right.
She's familiar with what the report is. The issue is when did she get it and when did she see it?
Michelle Kessler, you were at the office at certain points in time on September 12, 1994, isn't that correct?
That's correct.
And you said that given the fact that this was a confidential case, only certain people at SID were given access to reports, or to this report, if you will. Is that correct?
That misstates the testimony, Your Honor.
Roll. Counsel, Mr. Walsh, I'm going to allow you to make objections concerning the scope. However, the prosecution is the real party in interest, and if they choose not to make evidentiary objections, that's their choice.
Thank you, Your Honor.
Could you repeat the question?
Sure. Given the fact that this was a confidential case, who at SID did you authorize to have access to the Cellmark report dated September 8th that was faxed to your office on September the 12th?
assumes facts not in evidence that she made such authorization.
Overruled.
I didn't know the report was coming, so I would have given no such authorization.
Well, prior to this report coming, since you said this case had already been classified as a, had already been characterized as a classified case, had a decision,
Sustained. Rephrase the question. Confidential case.
I'm sorry, what?
Confidential case.
Oh, confidential, I'm sorry, thank you. Since this case had already been characterized as a confidential case, what policy was in effect as to who at SID would have access to the reports that came from Cellmark?
Anyone that was involved with the serology aspects of the case, which at that time would have been off the top of my head, and there could have been more because I don't remember who was doing what moment. Mr. Matheson, Mr. Yamauchi, and those are the only two that I can recall at the time,
And of course, yourself.
and myself.
And it was your practice to read the reports from Cellmark at some point after they were received, isn't that correct?
Not necessarily. Sometimes Greg Matheson would just fill me in on what it was.
Ms. Kessler, do you recall having a discussion with me and Barry Scheck at the office of the city attorney on July 13th of 1995?
Yes.
And at that time, during that meeting, didn't you say that you personally read every single Cellmark and DOJ report that came to the office?
No, I didn't say that.
Okay.
I said I looked at them if we got them, but we never got any DOJ reports.
Okay, so you said, in other words, that you did look at those reports that did come to the SID laboratory, is that right?
Yeah, but I didn't read every single one word for word, no.
Okay. So it would be a fair statement that you did look at this report, which is dated September 8th, and that was faxed to the SID laboratory to Michelle Kessler at some point.
At some point, I saw a copy of the fax.
Okay. I'm sorry. So you're saying that the only three people at SID who would have access to this report would be Colin Yamauchi, Gregory Matheson, and yourself, is that right?
Misstates the testimony asked and answered.
Overruled.
Those are the only people. However, this report was faxed to someone. It was not faxed to me. I don't know who that individual is. So that individual would have to tell you who had access to that report.
Didn't you tell us on July 13th, Ms. Kessler, that the person who actually received the fax at the fax machine was Gregory Matheson?
I'm assuming that, but I don't know that personally. I don't have personal knowledge of that.
Did Gregory Matheson tell you at any time between September 12th, 1994 and today that he was the person who stood by the machine and personally received it?
Calls for hearsay.
It's a
Sustained.
402 hearing, Your Honor. I believe the court can consider hearsay.
Sustained. Rules of evidence still apply, Counsel.
As the head of this laboratory, do you know who it was who received a fax on September 12th, 1994 at the SID laboratory?
No foundation for personal knowledge. Calls for hearsay.
Overruled.
I have no personal knowledge of who received it.
As
All
the
right,
head
hold
of...
on, hold on. Where's the fax machine located in the laboratory?
It's in the internal offices outside my office. It would
Right.
be like back in your chambers.
So it's part of your office complex?
That's correct.
All right. And who is the SID person whose job it is to maintain the fax machine, to keep it full of paper?
Well, at that point, we had no one because I didn't have a secretary. So it was just the people within the offices.
Proceed.
Did you at any time, as the head of the laboratory, undertake to find out through an investigation who it was who personally received the fax on September 12th, 1994 from Cellmark Diagnostics?
Not relevant and calls for hearsay.
Overruled.
I can say that I was told by someone that they received it.
And who was that person?
Calls for hearsay, Your Honor.
Overruled.
Greg Matheson.
Motion to strike.
Overruled.
Now, you said that you named the people at SID who were given access to that report. You also said a little bit earlier that people in the investigating agency were also entitled to have access to that report. Did I misunderstand you?
I didn't say they had access to the report. I said that we would have told them what was in the report if they had asked.
All right. And who were the people at the investigating agency who would be entitled to be told what the substance of the report was, had they asked?
No foundation.
The lead investigators, Tom Lang, Phil Van Adder, and I suppose if Captain Gartland had ever asked for it, he would have gotten it, for example.
Where were these reports kept once they arrived? These reports, I'm referring now to Cellmark reports.
In Greg Matheson's office.
And where is Greg Matheson's office in relation to your office?
It's in the serology unit.
Well, is Greg Matheson's office still in the serology unit, or has it moved?
It's moved now.
He's in the same suite as you?
Yes,
Okay. And would they be locked up in Mr. Matheson's office?
yes.
Mr. Gold, I don't believe so. Mrs. Robinson, is that fresh? No, let me get you a fresh one. Mr. Goldberg, does the prosecution have a copy of this particular report dated September the 8th that has the telephone number to which it was faxed?
No, my copy doesn't have a telephone number to which it was faxed, but it does have a number from which it was faxed.
All right.
So it appears to be similar to...
Ms. Kessler, do you know where the original September 8th report faxed report from Cellmark is?
No, I do not.
Actually, Your Honor, the People's copy is better than ours for one important reason. What it has on top of the line that shows the faxing from Cellmark, it has a line dated September 16th showing that this same copy was faxed from SID Piper Tech to the District Attorney's Office. So I think you probably would want a copy of their copy.
Although we already know that because that's on the facsimile transmission sheet.
I understand, but I'm just saying that every single page has that additional line which was not visible on our copies.
All right, proceed.
Can I simply just give this to
Well,
Deidre?
that's my only copy.
Well, no, I'm just going to ask you to make copies of it, if I may.
Let's not waste the court's time at this point to do that.
Fine. Now, Ms. Kessler, you learned, did you not, that some of the results reflected in that Cellmark report, which was faxed to SID on September 12th, appeared in newspaper articles on September 14th and September 15th of 1994. Do you know that?
Calls for hearsay.
Oh.
I know that at some time they appeared in newspaper articles. I don't know what day.
Well, not the exact date, but Ms. Kessler, you're aware of the fact that it appeared in newspaper articles during that same week of September 12th, 1994. Isn't that correct?
It also calls for a conclusion as to what was the source of the newspaper articles.
Sustained. Results is vague, counsel.
All right. Did you learn, Michelle Kessler, that on September 15, 1994, the Los Angeles Times published an article in which it said that final DNA tests in the O.J. Simpson murder case point to Simpson as the source of at least some of the blood drops found near the bodies of Nicole Brown Simpson and Ronald Goldman? Sources close to the case said Wednesday.
Calls for hearsay, no foundation for personal knowledge.
Overruled.
I'm not aware of that particular article. I just know there was some.
Ms. Kessler, when you were interviewed by Mr. Scheck and myself on July 13th, 1995, didn't you tell us that Mr. Matheson showed you this report after it was faxed to him, and that you were aware at about the same time that portions of the report had been leaked to the press? Didn't you tell us that on July 13th?
That's unintelligible.
Sustain. Rephrase the question.
Didn't you tell us on July 13th, 1995, Ms. Kessler, that you learned that week, within a couple of days after September 12th, that portions of that report had been leaked and appeared in the press?
Calls for hearsay.
Overruled.
I heard that some of the Cellmark results or some of the Cellmark work, which were also in that report, had been leaked to the press. I don't know if they came from that report or what their source was.
Motion to strike the witness's answers, calling for speculation.
Overruled.
Now, you also Don, do you have the copy that was, this is the copy that's actually in evidence? All right. I'll show you, what number is it, Your Honor, that was marked?
Which, the Cellmark report?
Yes, with the cover fact sheet to Marcia Clark.
No, the cover fact sheet is only, is 1282.
Okay.
Has DNA discovery number 01728.
I'm going to show you, Ms. Kessler, defendants 1281 and 1282, and ask you to take a look at it. The fact sheet from LAPD, SID, of the Cellmark report to Marcia Clark at the DA's office on September 16th. Does it indicate on the cover sheet that you are the sender of this report?
My name is down there at the bottom, but that's not normally where I would put my name. This is not in my handwriting, so I don't recall directing someone to send it.
But it is your name that appears at the bottom of that cover sheet? And it's printed?
Yeah. No, it's handwritten.
That's
And,
what I mean. It's not part of the
oh, it's script.
typed form.
Right,
It's something that was written in.
right.
Thank you. And, Ms. Kessler, when you learned that,
Excuse me, counsel. Do you know whose handwriting this is?
No, I don't recognize it.
Thank you. Proceed.
Ms. Kessler, when you learned that some of the results from Cellmark that are contained in the report that you received on September 12th and had not been sent out to the district attorney until September 16th appeared in newspaper accounts prior to the date that they were sent to Marcia Clark at the district attorney's office, did you, as the head of that laboratory, undertake any efforts to find out whether someone at SID was the source of that information?
Calls for conclusion as to the source of the newspaper accounts.
Overruled.
Well, I didn't feel we were the source, so I did no investigation. I presumed the leak had come from Cellmark. That was
Well,
my
motion-
assumption.
Motion to strike calls for speculation.
Overruled.
You said you didn't feel that you were the source of the leak. You meaning SID, I take, is that right?
That's correct.
Okay. What was your basis for making that conclusion?
It's not relevant, Your Honor. Calls for speculation.
Overruled.
I just feel that our employees have too much integrity and honesty and have been involved in many, many cases before, and we have never been a source of any leaks.
Did you make any inquiry of the other two people who you said had the limited access to the Cellmark report as to whether or not they were the source of the leak.
It misstates the testimony that they were the only ones that had access.
Sustained. Phrase the question. Just use the specifics, Counsel.
Did you ask Colin Yamauchi whether he knew anything about how this information was leaked to the press?
Not relevant.
Overruled.
I don't believe I asked him specifically. I believe my question was, in general, to the individuals involved, had they disseminated this report already somehow?
When you say you made this inquiry to the individuals involved, first of all, which individuals are you referring to?
I'm assuming, because I don't recall, that it would be Greg and Colin primarily. Probably Greg, and then Greg would have gone forth and asked the rest of the individuals.
A motion to strike is speculation.
Overruled.
And when did you have this inquiry of Greg Matheson?
I don't recall, right around the time of the leak.
Did you make any notes at all about your conversation with Mr. Matheson that you had with him around the time of this leak?
Your
No.
Honor, this whole subject is not relevant to the 402 hearing.
Overruled.
No, it wasn't important to me to do that.
Did you have more than one conversation with Greg Matheson about leak or leaks of DNA results in this case?
No,
Just this one conversation, you don't recall when or where it was?
no.
Other than a conversation with Gregory Matheson, did you conduct any investigation or inquiry or speak to any other individuals to try and ascertain the source of the leak?
No, I was convinced that it's not in the laboratory, so I wasn't concerned.
And other than based on a conversation with Greg Matheson and your own feelings, I guess you would have to characterize it, about the people who worked for you, is there anything else which was the basis for your conclusion that SID was not involved in this leak?
Your Honor, this is not relevant.
Overruled.
No.
Now, on September 20th of 1994, Gregory Matheson obtained PGM results on the socks in this case. You aware of that?
That misstates the testimony and evidence in the trial. I think it was the 18th.
Excuse me, Your Honor, at page
Overruled.
254.
Overruled.
Okay.
Are you aware of that?
I'm not aware on what date he got the results. It was
Now,
around that time.
Greg Matheson would report directly to you, is that correct?
He reports directly to me. In what context are you referring?
Well, generally speaking, first of all, in terms of the hierarchy of personnel at SID, would he report directly to you, or would there be anyone between Gregory Matheson and you?
He reports directly to me.
Okay. And you said that in this particular case, and correct me if I'm mistaken, that you would be kept informed by Greg Matheson as results came in dealing with analysis of evidence in this case. Is that correct?
Asked and answered.
Overruled.
Of anything significant, yes.
Okay. Well, would you agree that a PGM result on the socks conducted by Gregory Matheson in the serology laboratory, suggesting that the bloodstain was consistent with Nicole Simpson Brown, would be deemed, I'm sorry, with Nicole Brown Simpson, would be deemed significant in the case?
Yes.
Irrelevant.
Overruled.
And would it have been the practice in this case for Mr. Matheson to immediately report to you the results of this PGM testing on the socks shortly after he achieved those results?
Not necessarily immediately, but within a reasonable amount of time, depending on his schedule
Well,
and mine.
Greg Matheson's office is in the same laboratory as yours, is it not?
This is not particularly interesting, Counsel.
Had Mr. Matheson achieved the PGM results on the socks on September 20th, 1994, would he have presented those results to you shortly thereafter, without putting a specific hour on
For
it?
speculation.
Sustained.
Did you become aware of the PGM results that Mr. Matheson achieved on the socks from Mr. Matheson?
Yes,
Are you aware that on September 21st, one day after Gregory Matheson achieved the PGM results on the socks, it was reported in KNBC that DNA typing on the socks had reached the conclusion that the blood on the socks was consistent with having come from Nicole Brown Simpson?
Assumes facts not in evidence.
Overruled.
Also calls for hearsay.
Overruled.
I believe it was the day after. I did hear it, and I think it was the day after.
The day after it was actually aired?
I believe it was the day after I found out. So that would have been the 21st.
Okay. The day after you found out about the PGM results, you mean?
Correct.
Okay. And so if you found out about the PGM results on September 20th, and you learned or you heard on the news this report by Tracy Savage on September 21st that there had been a DNA match on the socks between Nicole Brown Simpson and the blood found on the socks, did you at that point conduct any investigation to see whether or not somebody at SID had been the source of that leak?
Not relevant.
Overruled.
I personally did not conduct an investigation. I asked the same two individuals who knew and did anyone say anything, but I did not personally conduct an investigation.
So with regard to the sock leak, it's your testimony that you actually spoke to both Colin Yamauchi and Greg Matheson?
That's correct.
Did you speak to them together or separately?
I don't recall.
And when you spoke to Greg Matheson, did he tell you who, if anyone, did know about the PGM results?
Calls for hearsay.
Overruled.
He told me one other person in the laboratory knew about it, and as far as everyone else, I made the phone calls, so.
Motion to strike. No personal knowledge.
Overruled.
Who was the one person in the laboratory that Greg Matheson said had knowledge about the PGM results?
Calls for hearsay.
Overruled.
He felt that Aaron Riley knew about it.
So other than Greg Matheson and yourself, the only other person who had been told the PGM results at SID was Aaron Riley?
No, and Colin.
Okay. When you spoke to Colin Yamauchi, did you ask Colin Yamauchi any questions about who had access to the PGM results?
Well, no. The
What-
results, Mr. Matheson had the results. Colin didn't have the results.
Well, I'm sorry, and I apologize if I'm sounding a little bit confused here. Did Colin Yamauchi know the PGM results on the socks at any time during September 20th or September 21st?
Sustained. Calls for speculation, counsel.
After Greg Matheson told you that Aaron Riley had also been told about the PGM results, did you have any inquiry of Aaron Riley?
Just that she knew about them.
Did you then talk to or meet with Aaron Riley to find out if she shared access to that data with any third party?
She indicated she had not.
Well, are you saying that you actually spoke with her?
Yes,
And when did that occur?
I don't know.
Did you make any notes of that meeting?
No,
Any notes of your discussions with Gregory Matheson about this leak?
no.
Based on your investigation, after you learned of the leak and the
Counsel,
Tracy
I don't-
Savage...
Counsel, I don't think it's appropriate to refer to it as a leak because it is misinformation. It is not a leak. A leak is something that is in fact correct.
Your Honor, in all due respect, I think there can be leaks of disinformation as well as leaks of information. This is something that, this would not be the first time something like that happened
Well,
in
counsel-
other situations.
I'm the one listening to this.
I appreciate that.
Proceed accordingly.
Based on your investigation, had the results of the
Assumes facts not in evidence conducted in an investigation.
Sustained. Rephrase the question.
based on whatever inquiries you made after learning the PGM results on September 20th and learning of Tracy Savage's report on KNBC on September 21st, had those results been given to anyone outside SID prior to the time that Tracy Savage aired her story on the news.
Yes.
And who had that information been given to?
The investigating officer, Tom Lang, and members of the district attorney's office, Marcia Clark, and I believe Lisa Kahn was in her office with her.
Were you the person who personally called the district attorney's office and gave them that information?
Yes, and Mr. Matheson was on another phone in the same room with me. Not a speaker phone, we were just on two separate phones.
Was that information given to Marcia Clark and Lisa Kahn on September 21st or September 20th?
I believe the afternoon of the 20th.
And you said that the information was also given to certain officers in the police department.
One officer.
And you said that was Detective Lang?
That's correct.
And when was that information given to Detective Lang?
It's afternoon of the 20th.
After your conversation with Ms. Clark?
I believe it was before.
And were you the person who also, was that done by telephone?
Yes.
And are you the person who actually communicated to Detective Lang the results of the PGM test?
Yes.
After learning of the Tracy Savage story, did you make any effort to find out whether individuals who you had given access to that information to, such as Detective Lang, provided access to that data to any third parties?
N-
Oh, well,
no, I would have no reason to inquire of them.
Did you share the PGM results that you obtained from Gregory Matheson with your husband, who's a detective at LAPD?
No.
Did you share the results of the September 8th report that was faxed to you on September 12th with your husband?
Well, number one, it wasn't faxed to me, even though I'm on the letterhead. It had to have a cover sheet, transmittal sheet. I never saw that fax till later. And secondly, no, I did not share it with my husband.
Well, when you say you never saw that fax until later, what do you mean, later that day or perhaps the next day?
Several days later, I think.
What is the basis for your belief that it was several days later?
Because at some point, someone asked me about the cell mark results, weren't they in? And I went and asked Greg whether we had gotten the cell mark results, and he said, yes, just a fax, and he showed me the fax.
Ms. Kessler, at the meeting you had with Mr. Scheck and myself on July 13th, 1995, didn't you tell us that you learned of the September 8th report shortly before you saw the results published in the newspaper?
Well, that could have been shortly before.
Okay.
I don't think that's when I saw it. I didn't see the results in the newspaper anyway, because I'm sorry, I don't read the LA Times. I listen to KFWB, so.
All right, but you said that it was shortly before you had learned that some of the results had been published in the newspaper. Is that correct?
Misstates the testimony.
oh, well.
Around that time.
Okay, so had the results been published in the newspaper as early as September 15th, then you may have learned about those results as early as September 14th. Would that be fair to say?
That'd be fair.
Do you know who Commander David Gascon is?
Yes.
And who is he?
He's a commander with the Los Angeles Police Department.
And do you know what his particular role is at the Los Angeles Police Department?
Is he still a commander?
I believe he's moved up in
Is he
life.
deputy chief now?
I believe he's a deputy chief.
Okay. At the time of this, in September of 1994, was he a commander then?
I believe he was still a commander at that time, and I believe he was in charge of press relations.
Okay. And had you had a professional relationship with David Gascon involving other cases in the past?
Very rarely I had spoken to him regarding other cases.
But you had spoken to him regarding other cases?
Not so much regarding cases. Oftentimes, press relations gives us the go-ahead to allow tours or allow press personnel to be interviewing us regarding other cases.
To your knowledge, does Commander Gascon friend of the reporter Tracy Savage? To your knowledge?
Sustained. Counsel, isn't the issue whether or not she shared any of this information with then Commander Gascon? Isn't that the issue?
Now, just so we can have a very good, clear sense of this chronology, Ms. Kessler, if the PGM results came in on September 20th and Tracy Savage ran her story on September 21st, isn't it true that the SOX had not even been sent out yet for DNA testing as of September 21st, 1994?
It's argumentative, this phrase.
Oral.
It's also compound.
Oral.
I don't believe they'd been sent out as of the 21st.
In fact, wasn't there a meeting held on September 23rd at SID, at which time a decision was made to send the SOX out for testing, for DNA testing?
My understanding was that, or my feeling was when speaking to Mr. Matheson on the 20th, that we were going to send them out for DNA. It was just a question of where and what testing, specifically what DNA testing would be done, and I don't recall the meeting you're referring to.
But you recall that there was some meeting held.
Your Honor, this isn't relevant.
Oral.
Let me just show you page.
Mr. Neufeld, you have 2 more minutes, so use your time accordingly.
Ms. Kessler, other than any inquiries that you made, are you aware that there was an internal affairs investigation into the source of leaks of DNA reports in this case?
I'm aware only because I was interviewed.
And who interviewed you?
Calls for privileged information, Your Honor.
Who interviewed?
Yeah.
Yes.
Oral.
I believe his name, I hate to even suggest because I'm not sure I remember who it was. I could make a guess.
Okay, approximately, don't guess, approximately when did this interview take place?
That's another one I can't remember. It seems to me it was in the fall sometime.
And to your knowledge, did internal affairs investigation conclude the investigation into this matter?
Objection calls for confidential information.
Sustained.
Was your interview by Internal Affairs into the leak issue transcribed, either with a tape, either by a reporter or by a tape recorder?
It was tape recorded.
One moment, Your Honor. Ms. Kessler, do you know Tracy Savage?
No,
You never met her?
no,
You ever spoken to her on the phone?
no.
Have you been the source of any information that have appeared in the newspapers or the press or television or radio about this case?
Absolutely not.
One moment. Did you give the information to David Gascon?
No.
Based on your own investigation as the head of the SID laboratory, Have you learned whether anyone else gave this information to David Gascon?
Ms. Cox not evidence that she conducted the
Sustained.
investigation.
One moment, Your Honor. Your Honor, I would ask that the witness provide at her earliest convenience, and I'll finish my examination now, with the name of the individual at SID who did examine her. And secondly, Your Honor, once we obtain the SID report, I would ask that she be glad to be recalled, Internal Affairs report, that we be permitted to recall it to continue the examination.
You're not finished?
I'm finished with that one condition, that's all.
All right. All right, Ms. Kessler, if you would you make inquiry as to who the detective or sergeant was from IAD who interviewed you, and provide that information to Mr. Walsh? Mr. Walsh, will you provide that information to us, please? All right, Ms. Kessler, you're excused, subject to recall. Thank you very much.
Okay.
One question?
With respect to the September 8th, 1994 report that you've been questioned about, do you have a specific recollection today whether you first saw this before the news report, the day of the news report, or after the news report?
No, I don't have an absolute recollection.
All right, thank you, Ms. Kessler.
Thank you.
All right, we'll take a 10-minute recess, bring the jury down, and we'll conclude Professor McDonald's testimony. All right, back on the record in the Simpson matter. All parties are again present. The jury is not present. Counsel, anything we need to take up before we invite the jurors to rejoin us?
Just one scheduling matter, Your Honor. I was contacted by Mr. Scheck. They filed a motion involving the contamination studies done by Dr. Gerdes.
Yes.
Could that be heard at 5 o'clock this afternoon? Or I think Dr. Gerdes is scheduled to testify tomorrow.
Are the lawyers available who are going to be arguing that issue? We may be able to get to it earlier than 5 o'clock today.
All right, well, fine, or 3 o'clock or 4 o'clock, whatever. But I would only ask that we do it after the Bosco matter, only because Mr. Scheck needs the time. So I would just ask that it be the last order of business.
All right, I think we can accommodate that this afternoon.
Because
Ms.
Mr.
Clark?
Scheck isn't here, that's all.
Is not here.
He's in Los Angeles, he's not in the building, and I'm just saying that that's why I'd like it to be at the end of the day.
All right. Ms. Clark?
May I make sure I believe Mr. Clark is here. I'd just like to make sure before I commit.
All right. All right, well, don't go away. I need to finish one other matter. There are two matters that the court had not resolved at the end of the day. Yesterday, there was the request for sanctions by the defense and an instruction to the jury regarding the dispute over Mr. McDonald's notes regarding the examination that was conducted on April the 2nd. I'm going to instruct the jury as follows when they return. Quote, during the course of yesterday's cross-examination of Mr. McDonald, it was suggested that Mr. McDonald's notes concerning the examination he conducted on April the 2nd, 1995, had not been turned over to the prosecution. These notes were in fact turned over to the prosecution on July the 17th, 1995. You shall therefore disregard any negative inference implied by the suggestion. All right, as to the request for sanctions regarding violation of the court's direction that any use of transcripts, that a sidebar be requested before transcripts are used. The court reporters have not provided me with the transcript, and I lost it on my computer yesterday. So I will take that under advisement because I have not reviewed the transcript. All right, Deputy Magnero, let's have the jurors, please.
Well, Mr. Goldman, when we have our next break, we'd like to address the court. Here concerning the letter forwarded to the court. There were discovery violations by counsel that we had raised with the court that had not been resolved. And Mr. Goldberg forwarded a letter to the court concerning those violations. I don't know when the court, I think that perhaps before the jury is instructed, as the clerk proposes, that the court would need to hear from Mr. Goldberg about this because it does bear directly on the defense right.
No, the issue was whether or not the notes had been provided to you previously. This issue of sanctions for discovery is something completely different. It's a different subject. All right, let's have the jurors, please. Gentlemen, please be seated. And let the record reflect that we have been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. Ladies and gentlemen, during the course of yesterday's cross-examination of Mr. McDonald, it was suggested that Mr. McDonald's notes concerning the examination he conducted on April the 2nd, 1995, it was suggested that those notes had not been turned over to the prosecution. These notes had, in fact, been turned over to the prosecution on July the 17th, 1995. You shall therefore ignore the negative inference implied by that suggestion. All right, Mr. McDonald, would you resume the witness stand, please? Mrs. Robertson, are we?
Yes.
Thank you. It's all right. All right, good morning again, Mr. McDonald.
Morning.
Sir, you were reminded that you were still under oath, and Ms. Clark, you may conclude your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen. Good morning. Good morning, Mr. McDonald.
Morning, Mrs. Clark.
Now, you stated, sir, that you were the director of a crime lab, correct?
That's correct.
And you still are.
Yes,
And that is the crime lab that you own and operate. Is that correct, sir?
that's correct.
How's your commute?
I commute by going from the upper level to the lower level. We either have the laboratory in the lower level and live in the upper level of the laboratory, or the laboratory is in the lower level of the home, either way.
So your laboratory is in the lower level of your home. Is that correct, sir?
That's correct.
And that's a profit-making business, isn't it? Hopefully.
It's supposed to be. Sometimes it isn't.
But isn't that where you derive most of your income, sir, from the laboratory?
Yes, directly or indirectly, yes.
And you have how many employees working for you, sir?
The current time I have one full-time, and other people come in from time to time as needed. I've had as many as 9 part-time people at one time.
But as far as regularly employed people that work for you on a full-time basis, it's 1. Is that correct?
That's correct. Mr.
So on a
Kish.
full-time basis, the lab consists of yourself and 1 other person.
That's correct.
Now, sir, in your lab, do you have a dark room?
We have 2 dark rooms,
Two
yes.
dark rooms. You are an accomplished photographer, are you not, sir?
I would say yes. I taught forensic photography and had 2 photo studios, yeah.
And would you consider photography to be a key aspect of your job?
Absolutely.
And do you feel that that is a very important aspect of the talents that you have, sir, your ability to photograph forensically?
Well, it's extremely important to document certain things. Sometimes photographs are not needed, but it's certainly a very important asset to be able to take good photographs.
As a matter of fact, sir, when you don't take notes contemporaneously with an observation, if you do take photographs, that will document what you see. Isn't that correct?
Mostly it will, yes.
Now, in this particular case, sir, on April the 2nd, 1995, who was directing the photography of the sock?
Basically, Dr. Lee was, but we alternated. We looked at different areas in the microscope, and I believe he actually took the photographs, but we both saw what it was prior to it being photographed.
Now, in this case, you have told us about 6 or 7 of those little balls, only one of which was brought into court in the form of a photograph, correct?
That's correct.
You did not direct that any other photographs be taken of the other little balls, is that correct?
No, actually, I didn't know how many photographs Dr. Lee took. This is the one that I have seen most often, and I think it's an excellent photograph to show what we saw.
But you did not direct that the other little balls that you are now describing verbally to the jury be depicted in a photograph so that they could see it as well.
That is correct.
And in your judgment, sir, in your opinion, wouldn't it have been appropriate or a good idea to take pictures of all of those little balls so the jury could see them all?
I don't believe so. We've described them. They were there, and one that was representative and perhaps showed the bonding of the not only the red material that dried to a fiber, but the fiber being bonded to a thread. I think that was the best one that we could use as an example.
Nevertheless, sir, the 6 or 7 little balls that you've described is a key aspect of your testimony, wouldn't you agree?
No, I think that's just making the same point 6 or 7 times over.
You don't think that it would be important to let the jury see everything that you saw on April the 2nd, 1995?
Sustained.
Let me ask you this, sir. It was Dr. Lee that directed the photograph be taken that was brought into court of that little ball on the fiber?
Yes, collectively, we both looked at it, and he said this is one we should photograph, and he did.
In your judgment, sir, you are an expert in blood spatter analysis, are you not?
Interpretation.
Interpretation, excuse me. And in your judgment, sir, who is the more qualified expert in blood spatter analysis, yourself or Dr. Lee?
I think that's an unfair question. I would not rate Dr. Lee in any way. We have worked on many cases together and been on many seminars teaching the subject of bloodstain pattern interpretation. I've never given an examination, and he's never given me one. I'd say he's eminently qualified, and I'd like to believe I am.
Then would you say, sir, that you're both equally qualified?
I think that's a fair statement, yes.
Then wouldn't you say that you also had equal say in what photographs should be taken to depict the observations and document the observations that you made on April 2nd?
That is true.
And you did not direct that any additional photographs be taken than the one that was presented in court today of that one little ball?
That is correct.
Now, you did not write, when you said notes the other day that you had taken, those notes contain no description of the little balls that you have come here to testify to. Is that correct?
That is correct.
Nor does the report you wrote on July 11th contain any description of the little balls that you have testified to here in court. Isn't that correct?
That is correct.
Now, if as a scientist, sir, you are supposed to document everything that you see contemporaneous with the observation, and photography is one way of doing that, wouldn't it have been very important, in view of the fact that you made no notes at the time of your observation, to take photographs of all of it, if only to refresh your own memory as to what you saw?
In this case, it wasn't necessary. I can remember those spots that I saw very distinctly, and I knew that photographs were being taken, and I could see no point in writing down a note that says, I'm looking at little red balls. I remember them very well.
Well, sir, isn't it true that in your report you wrote that the outer stain was a swipe, correct?
Correct.
And then,
Excuse me, yes, several times.
Overruled.
and then you testified, I believe yesterday, that you looked at photographs and based on your re-examination of the photographs, determined that in fact it was a compression, and so testified. Do you recall that, sir?
Yes, I do.
In that regard, then, sir, having had the photographs to review, you actually changed your opinion as to the appearance of a stain from swipe to compression. Isn't that true?
Objection, been over this several times yesterday.
Overruled. It's a new point, counsel.
I did not change my opinion. I changed my characterization. If you want to use swipe, or compression, they're basically the same thing. The difference is a slight marginal variation, and that's all.
If the difference is a slight marginal variation, sir, why did you not say that during direct examination when you were making the point to the jury that, in your opinion, this was a compression
Sustained.
and not a...
Sustained.
Nevertheless, sir, your documentation of the appearance of the outer stain was what led you to make a different characterization of the appearance of that stain. Is that correct?
It's not a different characterization. It is simply an adjective. Adding swipe makes it a little bit more on one side than another. Depending upon which photograph I look at, I could use either term. There is really no difference between them as far as that particular stain is concerned. Either term you like, I will agree with.
Then you would agree at this point, sir, it could be a swipe, it could be a compression, and it really makes no difference. Is that your testimony?
That is correct.
Nevertheless, it was the presence and the use of the photographs that you took to document your observations at the time of the examination that caused you to take a step farther away from swipe and testify that it was compression, was it not?
No.
Then what was it, sir, that changed your mind from the time you wrote your report indicating it was a swipe to the time you testified and indicated on direct examination it was a compression?
It was the photograph Dr. Lee took.
The photograph Dr. Lee took. And there are no other photographs than the one to document your observation of the little balls than the one little ball you brought into court today, yesterday. Is that correct?
Overruled. Last question on this line, though.
That is correct.
Now, sir, if you and Dr. Lee are of equal stature in the field of blood spatter interpretation, what was your role there? Why do we need two? Why did you need to have two people present to examine the
Sustained.
sock?
Sustained.
Can you tell us what your role was? Strike that. Dr. Lee, in your opinion, is as qualified as you are in blood spatter interpretation, correct?
Yes, I would say that.
And he was examining that sock under the microscope along with you, correct?
That's correct.
And he was directing what photographs should be taken. Is that correct?
We were deciding between ourselves which photographs should be taken. He merely took them.
Then can you tell us, sir, for what was your role in the examination on April 2nd, if the two of you were equally qualified looking at that same pair of socks?
Objection, argumentative and irrelevant.
Overruled.
I was there at the request of attorneys to conduct an examination with Dr. Lee. I have no idea why they asked for two. They might have asked for three, but that is not something that I am privy to. I don't know why they asked for two.
All right, your lab, your work is not monitored by any independent agency, is that correct?
Not that I'm aware of, no.
And I think that, will you agree, sir, that the only check or balance for quality assurance on your work is that an opposing side may read your report of your conclusions and disagree?
Objection, argumentative.
Overruled.
Well, they may read my report, and they may disagree, or they may agree with me. They don't disagree by reading the report. That depends upon what they feel.
I'm sorry. Right. But the only check or balance for quality assurance that you have, sir, is when the other side reads your report. They may agree or disagree, but that's your check or balance, correct?
You could call it that, yes.
There are no validation studies administered to you by outside agencies, is that correct?
That's correct.
No blind studies are administered to your laboratory by another agency or organization, is that correct?
Not by other agencies, correct.
And unlike Cellmark, where they have in-house blind studies to test their quality control or the accuracy of their testing methods and results, you have no such blind...
Evidence
Overruled.
and argumentative.
Sustained. Rephrase the question.
Sir, have you heard testimony from representatives of Cellmark that they do conduct blind studies of their own testing procedures and methods to make sure that their quality control is kept up?
Objection, irrelevant, and also I...
Sustained.
Do you have any blind studies that you conduct, sir, within your laboratory for purposes of quality control?
Yes.
And what is that blind study that you conduct?
I prepare samples, or we receive evidence, actual evidence, and Mr. Kish and I review it independently, and that would be, in my opinion, a blind test. If we agree, then we have conducted a verification of each other's ability to arrive at the same conclusion.
And if you disagree, do you publish the results, sir?
I can't remember when I've disagreed.
So you've always agreed with each other?
On evidence matters, interpreting bloodstain patterns, we discuss it, and we agree, yes.
And so if you always agree with each other, sir, it's only between the two of you working together, is that correct?
That's correct.
If you always agree, do you consider that to be a blind study that's a check on your quality control?
I sure do. I don't know what he's going to say, and he doesn't know what I'm going to say.
And
That's
nevertheless,
blind.
I'm sorry?
That's blind testing.
And if you should disagree, there is no record kept of that so anyone would know.
Objection, Your Honor, it's mere speculation.
Sustained. Rephrase the question.
You keep no records of the times you agree or disagree, is that correct?
Objection, facts not in evidence, so we testify they didn't
Sustained.
disagree.
Counsel, you're getting close there. Proceed.
How many years have you been working with Mr. Kish, sir?
Well, actually, he works with me. I would say, I think 6 or 7, something like that. He's assisted me with many bloodstain institutes, so I could go back and see the first one he helped me with. I think it was about 6 or 7 years ago.
Is he on your payroll, sir?
Yes, he is.
And you pay his, is it a regular salary that you pay him, or is it case by case?
It varies. It's a regular salary, but because I'm letting him do more and more cases independent of myself in somewhat of semi-retirement, you might say, I really do not have any financial control over some of his cases. Some I do. If they come to me and I assign them to him and he works on them, then he receives a substantial amount of the fee.
Okay. So he's dependent on you for his livelihood, is that correct, sir?
Yes.
And he's the one who is your check or balance as to whether or not you have made a correct interpretation or not. Is that right?
Yes, you could say that.
Is there any licensing required for your lab, sir?
No.
Or monitoring of your lab by an independent agency?
Not monitoring as such, but I was a member of the New York State Crime Laboratory Advisory Committee for many years, and there are 14 laboratories in New York State, of which my laboratory was one, and that was a discussion group more than certification or anything of that nature.
Right. Your lab is not certified by any agency, is that correct?
That is correct.
And the group that you just spoke of does not monitor your lab for appropriate operating methods or procedures, does it?
No, it does not.
And there are no requirements that you personally be tested at any time to prove that you are using approved methods in your analysis of cases. Isn't that correct, sir?
Nothing other than cross-examination such as this.
And that would depend on how closely you're cross-examined. Is that correct?
How detailed.
Assumes the fact it's not in evidence.
Overruled.
How detailed, not closeness.
Okay, I'll agree with you. How detailed the cross-examination is that correct, sir?
Yes.
And if the cross-examiner knows virtually nothing about bloodstain pattern interpretation, then the cross-examination will not be very detailed at all. Wouldn't you agree?
Well, speculation is irrelevant.
Overruled.
Well, it's difficult to say how much an attorney knows about bloodstain pattern interpretation. I've had several attorneys attend the Institute, and I would like to think that those attorneys could do a very good job. As yet, I've never been cross-examined by one of my former students, so I really don't know, but the more they know, the better job they can do, and it helps me a great deal because they don't ask questions which might seem logical but are scientifically incorrect.
Nevertheless, sir, the degree to which you are tested by cross-examination, since that is the only means of your being tested for your current knowledge of the state of the art,
Objection, Your Honor, that's not his testimony.
Sustained. Rephrase the question.
you indicated that the only way by which you are tested to show that you are using approved methods or sound methods of analysis is by the nature of the cross-examination. Is that correct?
I would use the word challenged rather than tested, but yes, that is correct.
In which case, you are only as challenged as the cross-examiner is effective. Isn't that correct?
Or as they wish to be, they may decide not to ask many questions if they feel it will not be to their advantage. I can't read their minds.
All right, let's move on.
All right, now, if the other side, whatever side that may be, disagrees with your opinion or your conclusion, does that give you some indication, sir, that your view may be in error?
Sustained.
Sir, do you believe that you can make mistakes?
Certainly.
And do you think that, have you ever drawn the conclusion that you have made a mistake based on the opposing side's disagreement with your conclusion?
No, that's not the kind of mistake I'm referring to.
Well, what kind of mistake are you referring to, sir?
And I made a mistake yesterday when I had the red eye last night. That's a mistake.
I'm sorry?
I couldn't get my airline reservation last night because I'm here today, and it was a mistake to tell my wife I would be home this morning at 10 o'clock. That was a mistake.
Well, sir, I'm talking about your work. Has it ever occurred that the other side has disagreed with your conclusion and that disagreement has caused you to re-examine your position and determine that you have made a mistake?
No,
And yet you have testified that the only check or balance, quality control, if you will, on your work is when the opposing side disagrees with you.
that is correct.
And yet when they do disagree with you, that does not cause you to re-examine your work and possibly conclude you made a mistake.
I've re-examined the things that they may have brought up and confirmed that, in my opinion, I was correct. I agree that anyone can disagree with me. That's their prerogative.
May we approach, Your Honor?
Yes, with the court reporter.
All right, Mr. McDonald, you indicated, did you not, that you've been paid $10,500 for your work thus far?
That is correct.
And how much are you paid per day to testify?
Ordinarily, if I'm out of the laboratory for a day, overnight, I charge $3,000. But in a case of this type, where I have traveled so many times and been away from the laboratory so many hours, I cannot charge a rate like that. I really don't know how much time I will charge for. I do not charge on an hourly rate when I've spent this much time. I'll charge a fair rate for the amount of time and effort I've put into this case.
All right, you, as of April 2nd, 1995, had been paid $10,500. Is that correct?
Yes, that includes some travel expenses and my associate and other things. That's not just a basic profit, so to speak.
And that was up to the point of your examination of April 2nd, 1995, that you had been paid $10,500. Is that correct, sir?
I believe so, yes.
And since that time, have you submitted any further bills?
No, I haven't had time.
And you have done further work, though, nevertheless, have you not?
Yes, I have.
You have done several days' worth of work. Would that be fair to state?
Yes, and I have been here 3 times, I think, since then.
And you have been here for the purpose of your testimony how many days now?
I'd say it's maybe 10 days, 8 or 10 days, very close to that. I can look it up. I was here from the 7th to the 12th, the 16th to the 20th, the 25th to the 28th, and I'm here again. So that would be...
I'm sorry, sir, say that again. 7th to the 12th of July.
Oh, excuse me. That was another meeting. That was in Philadelphia. I came the 16th to the 20th. That would be 5 days. And the 25th to the 28th, 4 days, and I've been here 2 days, so that would be 11 days.
Right. And ordinarily, in the average case, you charge $3,000 a day.
That is correct.
So if you were to
No,
charge...
that's to stay overnight. That would be 2 days.
All right. And in this case, you have 11 days down, correct?
That's correct.
So if this were your average case, you would have charged... What is... 33... This is terrible. This is terrible. What is it? Okay, roughly $18,000 for your work thus far, if it had been the average case, correct?
No, it would have been several average.
Wait. Mr. Fairtlow, keep your voice down. If I can hear you, it's way too loud. Sustain. Rephrase the question.
If you were charging your average fee in the average case at $3,000 per day after 11 days being present, how much would that be?
Sustain. He said he's not going to bill on his normal schedule.
And how do you intend to bill, sir?
I'm not really sure. I must confess I've never had a case that has been of this type. I will be fair and not do anything that will cost more money. I've saved the defense considerable money by using golden opportunities air flight books at $300 a trip instead of the first 2 were $1,409 a ticket. I think I've saved them $3,300 on that alone. I'm not trying to make a profit, just a reasonable wage.
Your Honor, there'd be an objection. Motion to strike is non-responsive.
Overruled.
Mr. McDonald, I'm tempted to ask you now what you intend to bill the defense. Can you answer that question, sir?
Not at this point.
Do you intend to bill them at 50% of your normal rate?
Objection. Asked and answered, Your Honor.
Overruled.
I really don't know. I've never had a case like this. I will be fair and charge them what I think the amount of time I've put in would have been had I been in my laboratory. I do not charge a rate every day because I don't spend 8 hours a day.
Mr. McDonald, are you attempting to convey to this jury that you're not in this for the money?
Sustain. Sustain.
You do intend to make a profit on your work in this case, do you not?
I hope so, yes.
And since you have spent at least 11 days since April the 2nd of 1995, you do intend to make more money than the $10,500 you've already been paid. Isn't that correct?
I really don't know until I have sat down and assessed the time I've spent. I would say that is an approximation that might be accurate, but I do not wish to limit my bill by stating in court what I'm going to charge. I have done that before, and that's all the attorney would pay me, because under oath I said I'm going to charge $400 more, and it turned out to be $550 or something, and they wouldn't pay me the extra $150. So that's why I say I'll be fair, but I don't want to commit myself to something and then find out I have to live with it and feel I didn't get a fair price.
All right. Do you feel that you will bill at least $10,000 more for the services you've rendered?
Objection, ask the answer.
Overruled.
As far as the amount of expenses go on top of what I have done, I would say that's approximately close.
To the minimum that you will bill?
No, it might exceed it. I don't know.
All right, let's move on.
Sir, you indicated that you are a New York State Crime Lab board member
I
for the
was.
advisory committee?
I was, yes.
And isn't it true, sir, that you last attended a meeting of that advisory committee in 1982?
That's probably right. They quit sending me the notices of the meeting, and so I couldn't go.
And you were not involved in quality control, isn't that correct?
That's correct.
Now, at this point, sir, with the one photograph of the one ball that you have shown us, at this point, all we have is your memory and your testimony to rely upon for the appearance of all the other little balls, the 6 or 7 that you've seen. Is that correct?
Objection, argumentative. Ask and answer on this subject 6 times.
Sustained.
May we approach, Your Honor?
Proceed.
No, I have not on a question. May we approach?
Yes. All right, thank you, counsel. Proceed.
At this point, in view of the fact that we have no photograph of the 6 or 7 other little balls, we have only your testimony to rely on. Is that correct, sir?
Objection, argumentative. Ask and
Overruled.
answer.
Sustained.
I didn't get an answer last time.
I sustain the objection, counsel.
Sir, is it your testimony that we rely on right now with respect to the appearance of how those other little balls looked? Your verbal description.
Overruled.
Objection, ask and answer.
That's a different question. You can answer the question.
Apparently so.
And, sir, you cannot say when those little balls got onto that inner surface before your examination on April 2nd, 1995. Isn't that true?
Objection,
is
asked
true.
and answered yesterday.
Overruled.
That's true.
And you cannot say that the compression stain that occurred on the outer surface of the sock was made at the same time that the little balls got onto the inner surface on the other opposite inner side?
I can put a limit on it, yes.
But you cannot say that they occurred at the same time, can you, sir?
No, they couldn't have occurred at the same time. One had to precede the other, if maybe by just a second or a fraction of a second. But the inside did not occur on surface 3, did not occur before 1 and 2.
And it didn't, and you cannot say exactly when it occurred after the outer compression stain was made. Isn't that correct, sir?
That's correct.
And you cannot even tell this jury that those little balls on the inner surface are associated with the outer compression stain. Isn't that correct?
I conclude that they were.
But you cannot tell this jury that they were absolutely associated with the same outer stain. Isn't that correct?
That is correct.
Now, sir, just with respect to the outer compression stain or swipe, either one that you say it now can be, you cannot exclude the possibility, can you, that the stain was made during the commission of the murder at Bundy. Isn't that correct?
Objection asked and answered yesterday.
Sustained. That question was asked yesterday.
So you cannot exclude the possibility, then, that that outer compression or swipe stain was made by making contact with the step covered with the blood of Nicole Brown. Isn't that correct?
Objection asked and answered.
Overruled.
That is correct.
And you cannot exclude the possibility that that outer compression or swipe stain on the sock was made at the time of the murder as the murderer stepped near the neck of Nicole Brown. Isn't that correct?
The neck, it's possible, yes, but I'd sooner think your example yesterday of a thumb or something that sticks out would be more likely. The neck would be too wide an area of blood staining to limit the transfer to that size stain. I mean, it might be possible, but I'd agree more with a thumb or something that sticks out.
Then you would agree, sir, that it would be more probable that it would be the thumb or bloody hand of Nicole Brown that could have come in contact with the sock to create that compression stain. Is that
Sustained.
correct?
Sustained. Speculation, counsel.
You cannot exclude that possibility, can you, sir?
Objection asked and answered yesterday.
Overruled.
And argument.
Sustained.
I cannot exclude it.
I'm sorry.
Wait,
Oh, I'm sorry.
sustain the objection. It is speculation. Proceed.
Sir, can you exclude the possibility that the stain on the outer, stain that you call a compression or swipe could have been made by brushing up against the bloody hand of Nicole Brown?
Speculative and asked and answered.
That was asked yesterday. Sustained.
All right, sir, you were not present. We showed photographs yesterday of the phenol test done with that swab in the picture. Do you recall that?
Yes,
And we discussed the performance of that phenol test that uses distilled water to perform the test, correct?
you can use distilled water, yes.
And it was apparent to you from looking at the photograph of the sampling step that was being shown in that photograph that that was the method that was being used in that with the sock, correct?
Correct.
Objection asked and answered.
Overruled.
That's
Now-
correct.
All right. Now, that test, you were not present when it was conducted. Isn't that correct?
That's correct.
You do not know how much pressure was applied by the person swabbing the sock with that Q-tip, correct?
That's correct.
You do not know how much water was used in swabbing the sock with that Q-tip, correct?
I don't know how much they used. I know how much they should have used.
Okay. But you don't know how much they did use, do you?
That's correct.
And you don't know how large an area was swabbed, do you?
No, I don't.
And if the blood was difficult to see and that test was being conducted under normal lighting, in an effort to do a blood search with that swab, it could have been a very large area, could it not, sir?
Objection, speculation.
Sustained.
Nevertheless, you
Excuse
do
me,
not know
just a
how
second.
large an area was.
Excuse me, counsel. If I hear the bases and I hear urgings for objections, and if I can hear it, the jury can hear it. Proceed.
Since you were not present then, sir, you cannot tell us how large an area was swabbed with that swab, correct?
I can state that it did not go to the edge of the stain itself because the blood is very clear, crisp, and sharp at the edge of the stain. Had a swab that was wet gone into that area, it would have diluted and diffused it, and it would not look as it does. So it would be confined more to the center than the periphery. That's the only limit I can put on it.
With that limitation, sir, but you cannot tell us what portion of the stain contributed the little balls you saw on surface 3, whether it was the periphery, the periphery or the center of the stain, can you?
Yes, I can eliminate the periphery because it did not soak through the fabric. Only the center area soaked through. So that's the only area that could have caused the staining on the third side.
And that's the only area where the phenol test was conducted, in your opinion, sir?
That's where they should have conducted it, where it's the most concentrated, yeah.
Well, didn't you just testify, sir, that based on your observation of the periphery of the stain, that the way it appeared, there was no water swabbed around that periphery that you saw?
Objection as to the term water swab.
Sustain. Misstates the evidence is what the correct objection is, counsel.
Sir, we discussed the performance of that phenol test using distilled water, correct?
Yes,
And in the sampling process, you would use a wet Q-tip to swab the area to see if there was something that appeared to be worth testing, correct?
yes,
And you were not present when that test was performed. We've already established that, correct?
correct.
So in the swabbing process with a wet Q-tip, using an amount of pressure you're not aware of, is your opinion based on what you saw that the periphery was not sampled in that manner, that the center of the stain was sampled in that manner, correct?
Objection is the form of that question.
Overruled.
Yes, that's correct if it was very wet, the Q-tip.
And it is your opinion, sir, that the little balls on surface 3 came from that center part of the stain where you opine the swabbing was done.
It was done through the cutout, which is basically the center.
Which is where you opine the swabbing was done.
That's correct.
Did you test the little balls in any manner to determine whether or not, if they were blood, they were diluted in some manner?
The answer is yes to that.
Sustain. Correct. Re-ask the question.
Did you test the little balls in some fashion to determine whether, if they were blood, they were diluted?
I didn't do any testing. I did an observation, and they were deep red and did not appear to be diluted at all.
Nevertheless, sir, you did not test. Is that correct?
I don't know what test you could apply on something that small. I did not. I don't think anyone could.
So then you cannot tell this jury that whatever it was not diluted in some fashion, can you, sir?
Objection misstates his testimony.
Overruled.
I can conclude it wasn't, but I cannot say absolutely, one, that it is transferred from the outside, and if it were, it would be blood, and two, that it is not a concentration in some fashion, but I cannot conceive of how that could occur. It appears to be a fresh sample of a red fluid that is dried and bonded to a fiber.
Sir, isn't the basic tenet of science, the cornerstone of it, testing, sir?
I think it's observation and then
And testing, is it not, sir?
Objection, he has to be allowed to finish his answer.
Sustain. Let him finish before you start the next question.
So it's observation and then testing. You have to observe something to determine what you might test for. I think it goes in that order.
Right, and it's based upon your observation, you form a hypothesis, do you not? Or a theory, do you not?
I formed a conclusion.
But then you go to test that conclusion to determine whether it is correct or not. Isn't that true, sir?
If it's possible to do so, you should, yes.
And is it not true, sir, that on occasion it will happen that you have a theory based on your observation that is disproven by testing? Doesn't that happen, sir?
Vague objection.
Overruled.
It could, yes.
And in this case, sir, you formed a conclusion based on your observation, which you could not test. Isn't that correct?
That is correct.
And so you cannot rule out the possibility that whatever you observed that substance was in those little balls was diluted or not. You cannot rule out the possibility that they were diluted, can you, sir?
Objection has to answer.
Overruled.
I can't absolutely rule out anything in any instance, and in this case, I could not absolutely rule it out as a scientist.
Nevertheless, if you had tested those little balls in some fashion, you might have been able to. Isn't that
Sustained.
correct?
Sustained.
And, sir, you cannot rule out the possibility that those little balls were created at the time that the phenol test was conducted on August 4th. Isn't that true?
It could only be ruled out if the testing was done in the normal procedure, not using a saturated Q-tip. That is not what you use when you have a stain of that size. So if it was done properly, there would not be enough liquid to dissolve any blood and transfer it to the inner surface, surface 3, and if it was, it would not appear that red. That is my conclusion.
And what tests did you do to support that conclusion, sir?
There is no test you can do except observation with good optical equipment.
Sir, what experiments did you perform on the material of this sock to show that a phenol test using distilled water on a swab would not produce those little balls on the opposite inner side?
I didn't have the socks to experiment with. I didn't do that.
Did you make any attempt to experiment, as I've suggested, performing a phenol test on a blood stain to see if that would cause some seepage of microscopic quantities onto the opposite inner side?
Objection, no foundation.
Overruled.
Not on that sock.
Did you attempt to do it on any substance or material that was identical to or very similar to that sock?
Yes.
You did a phenol test and attempted to observe whether there were microscopic particles on the opposite inner side after you performed the test?
I didn't do a phenol test or phenolphthalein test because I knew it was blood. I put it on the material myself.
And can you show us the documentation from the phenol test that you conducted with distilled water and a swab on material just like those socks?
Sustained. Sustained.
Sir, what experiment did you perform on material just like these socks to show that a phenol test on a blood stain on an outer surface that is just like this blood stain would leave the microbes or not leave those little balls on the opposite inner side?
I applied blood to a similar material, a stocking that was of the lightweight polyester composition, and brushed it on lightly, enough to soak through. And after that, I cut out a portion and observed the side opposite corresponding to side 3.
No, objection. Objection, Your Honor. This is not my question. This is non-responsive.
Sustained.
Ask motion to strike.
Answer is stricken.
Mr. McDonald, please listen to my question. I am asking you now whether you took material just like these socks with blood on it, performed a sampling with a wet Q-tip, pressing down with that wet Q-tip to sample the blood, and then observed the opposite inner side after it had dried to see if there were little balls like those observed on this sock. Did you do that, sir?
Not that specific experiment, no.
Thank you, sir. And lastly, sir, you cannot rule out the possibility that those little balls that you observed are the result of someone with a bloody hand pulling off their socks, can you?
Objection, asked and answered yesterday.
Sustained.
I have nothing further.
Mr. Neufeld.
Thank you. Morning, ladies and gentlemen. Hi. One moment. Ms. Clark asked you a series of questions this morning about your several trips you made out here during the last month. You recall those questions?
Yes, I do.
Did you make several trips out here during the last month because you had been told you were going to testify, and then because of scheduling problems, you then had to go home and return again, and go home and return again?
That's correct.
One moment. Your Honor, before I continue this redirect, can I have a brief sidebar?
With the court
Thank
reporter,
you.
please. All right, thank you, counsel. Mr. Neufeld?
Thank you. What I would like you to do, Professor McDonald, for most of these questions, is use the same terminology that prosecutor used, namely, we have side 1, side 2, side 3, and side 4 of the socks. And could you just quickly show, perhaps using your own sock again, what we mean by that with side 1, side 2, and side 3, and side 4?
I use my sleeve instead.
Fine.
If the stain is on the top, that is considered side 1. Side 2 would be inside where liquid could soak through. Side 3 would be opposite if the garment were lying flat, and side 4 would be the outside, which would be opposite the side 3.
Thank you. Now, on cross-examination, the prosecutor asked you a series of questions concerning the manner in which the socks had been handled prior to your examination on April 2nd. Do you recall her asking you those questions?
Yes, I do.
And do you recall her in those series of questions asking you whether, for instance, if the socks were twisted in a certain way, could that produce the red balls that you observed on surface 3? Do you recall her asking you that question?
Yes.
All right. Professor McDonald, in your opinion, could twisting the socks result in producing the red balls that look like blood bonded to the fiber on surface 3?
No, it could not.
Why not?
You can't create little round balls of fluid that dry on a fiber by simply twisting a garment. You can't do it.
Professor McDonald, could freezing and thawing the sock in the laboratory's freezer after the stains had already dried produce the red balls that look like blood bonded to the fiber of surface 3?
No, they could not.
Why not?
There would have to be a substantial amount of moisture, and that would show up by diluting and diffusing.
See that picture of Dr. Henry Lee
Yes,
stretching
I
the
do.
socks?
Yes, I do.
Okay. In your opinion, could Dr. Henry Lee's stretching the socks as shown in that photograph result in producing the red balls that look like blood bonded to the fiber on surface 3?
No, that could not produce.
Why not?
Again, there's no moisture, there's nothing that would cause a transfer. They would have to have been there prior to this photograph.
I show you prosecution's exhibit number 555. Here again, you see a photograph that was shown to you by the prosecutor yesterday of Dr. Lee apparently turning a portion of the socks inside out. Sir, in your opinion, could Dr. Lee's turning these socks inside out result in producing the red balls that look like blood bonded to the fiber on surface 3 of the sock?
No, it could not.
Why not?
Again, it requires moisture. The creation of those red balls was due to a liquid drying, and merely manipulating the socks cannot produce that. It'd have to be there.
Professor McDonald, could using a scissors or a scalpel to cut pieces of the sock out for additional testing result in producing the red balls that look like blood bonded to the fiber on surface 3 of the sock?
No.
The prosecutor also showed you a photograph of somebody prior to the time that you examined the socks on April 2nd conducting a presumptive test on the sock before any area of it was cut out. In your opinion, sir, could conducting a phenolphthalein test on the outside surface of that stain prior to the time that any of it was cut out result in producing the red balls that look like blood bonded to the fiber of surface 3?
It could only do that if there was an abundance of liquid to dissolve blood from the surface. And I'm not being disrespectful, I'm saying it would be a sloppy technique in that there would be a lot of liquid on the Q-tip. Ordinarily, you use just a dampening, not a volume of water.
And when you looked at that picture, did you see what appeared to be you said a yellow oval on the piece of paper.
Yes.
And would that be consistent with your understanding that when it is done properly, someone simply takes the swab and dabs that pre-existing wet stain on the paper and then applies it to the material on the sock?
That is one way it's done.
Overruled.
That is one way it's done because it requires a minimal amount of liquid to dissolve the surface of the blood stain or the stain being tested to determine if presumptively it could be blood. The amount that's removed that is necessary for test is very, very small. The phenolphthalein test is a very sensitive test.
And sir, is it your opinion if the test was conducted in a normal fashion and simply dab that yellowish oval, would that produce, or could that produce, the red balls that look like blood bonded to the fiber of surface 3 of the sock?
No, it would not.
Now, prosecutor asked you whether, since you saw the evidence of a wet transfer stain on surface 3 on April 2nd, that you can't say for sure when the stain on surface 3 got there. Isn't that correct?
That's correct.
Well, sir, in this case, there has already been testimony that the first time anyone observed a bloodstain on the sock was August 4th. The question I have for you, sir, is, can anyone tell when before August 4th any of the stains on that sock got there?
No.
You recall when Ms. Clark asked you questions about when the transfer stain appeared on surface 3, and she gave you a series of different dates, and you said you couldn't rule out those dates. Do you recall that?
Yes.
Likewise, sir, can you rule out, or can any scientist rule out, that the initial bloodstains found on that sock were not put on that sock on August 3rd
No.
or August 1st?
No objection, I call for speculation.
Sustained. Overruled.
One second. You recall the prosecutor asking you some questions about differences between the term swipe and the term compression. Do you recall that?
Yes, I certainly do.
And I believe you just said to her on cross-examination that they were quite similar, and that in fact a swipe was a subcategory of a compression stain. Do you recall that?
Yes.
But are both those stains, that is, a swipe or a compression, significantly different than the stain that results from blood spatter?
Oh, yes.
Overruled.
And what is the difference?
Wait a minute.
I'm sorry.
You need to let your witness finish his answer.
Okay.
They're significantly different.
How are they different, sir?
A spatter is projected blood that, much like a drop, would fall onto a surface. And again, it will go indiscriminately between fibers as well as on the surface. A swipe pattern or wiping of the surface with blood, a transfer pattern, will only be on the surface of the fibers unless there is sufficient blood to penetrate the central area. And that is why I characterize this as a transfer pattern with indications of lateral motion, which could make it then a swipe pattern.
Sir, you stated that you observed a wet transfer stain on side 1 and side 2 and side 3 of the sock. Is that correct?
Yes.
Did you observe any evidence of a stain on what you've now described as side 4, the
No.
outside surface opposite side 3?
No, there was very little on surface 3, not sufficient to penetrate the fibers and come outside 4.
Does the absence of any blood on side 4 indicate that these red balls seen on side 3 did not soak through from side 4?
Certainly.
Is that additional evidence that these red balls But look,
Sustained.
now the prosecutor asked you some other questions about the April 2nd examination that you attended with Dr. Henry Lee. Do you recall that?
Yes.
And she asked you questions about the presence of Gregory Matheson from the LAPD SID laboratory. Do you recall that?
Yes.
Was Gregory Matheson present in the room during the entire time that photographs were taken of the socks through the microscope?
During the photography, yes.
And prosecutor asked you why in your own notes you didn't personally describe seeing the red balls bonded to the fabric on surface 3. Who was the primary note taker on April 2nd?
Dr. Lee.
Sir, have you ever heard the expression that a picture is worth 1,000 words?
Certainly.
In your professional opinion, sir, is a photograph an adequate way of documenting what you observed in the microscope instead of simply writing it down in your notes?
Yes.
Why is that?
Well, as you just stated, a picture is worth 1,000 words, and I could not sketch it or describe it as accurately as it can be recorded on film.
Earlier yesterday, the prosecutor asked you some questions about your academic career. Before you started teaching at Milton College, what was the extent of your education?
I had a 4-year degree with a major in chemistry and a minor in mathematics from Alfred University, and a 1 year of graduate study in chemistry at Alfred University.
Were you proud of the fact that you were asked to teach college students without receiving an advanced degree first?
I was both proud and surprised. The recommendation from Dr. Saunders must have been quite good. I haven't seen it.
And sir, remember when I asked you about the John A. Dundero Award that both you and J. Edgar Hoover had been recipients of?
Yes?
When you were selected as the recipient of this award for outstanding achievement in your field, did the size of the college you attended or taught play a role in the selection process?
I doubt it very much. I don't know whether they even know which college I taught at or attended.
The prosecutor asked you questions about perspiration. Is there any evidence in the sock stains that you observed of the presence of significant perspiration, sir?
No, there's...
Objection, speculation, Your Honor.
Overruled.
Objection, no foundation.
Sustained.
Sir, is there a basis for you to conclude whether or not those socks had significant amounts of perspiration at the time that the blood was put there?
Objection, no foundation, cause for speculation.
Overruled.
Yes, there is.
And what is that basis, sir?
The appearance of...
Objection, no foundation.
Overruled.
Objection, outside of Stover's expertise, speculation, Your Honor.
Overruled.
The appearance of the blood on the surface of the fibers around the periphery is very clear and sharp. If any significant amount of moisture, such as perspiration, had penetrated those fibers, they would have been diluted and diffuse.
At the end of her cross-examination yesterday, the prosecutor asked you whether the stain observed on the outside of the ankle portion of the sock could have been made had the wearer of the sock brushed against Nicole Brown Simpson's hand or another bloody surface at the Bundy crime scene. And I believe you answered that it could. Do you recall that, sir?
Yes.
But let me ask you this, sir. Given all your observations on sides 1, 2, and 3, and 4 of the ankle area, are the transfer stains that you observed consistent with the wearer of the sock brushing against Mrs. Brown Simpson or some other bloody surface at the Bundy crime scene?
Not as I understand the evidence in the case.
And why not, sir?
The crime scene, as I understand it, is at least 6 minutes from the residence of Mr. Simpson.
Objection, Your Honor.
Sustained.
Ask the
Sustained.
jury, Your Honor.
Answer stricken. Juries to disregard it. Proceed.
Prosecutor also asked you whether or not the stain is consistent with Mr. Simpson with bloody hands taking off the socks. Do you recall that?
Yes.
Well, if Mr. Simpson, I'm sorry, again, sir, based on your observations and your expertise, is the evidence you've seen, I'm sorry, withdrawn. I'll rephrase the question. Let me ask you a hypothetical, Professor McDonald. If Mr. Simpson had come home with blood on his hands from Nicole Simpson Brown and went upstairs to his bedroom to take his socks off, would you expect to see a trace of his blood on the light switches in the house?
Objection, speculation, since facts not
Sustained.
evidence.
Would you expect to see blood on the banister going upstairs?
Same objection.
Sustained.
May we have a sidebar, Your Honor?
No.
Are you aware of the fact, Professor McDonald, that the criminalists in this case have testified that there were absolutely no bloodstains consistent with Nicole Brown Simpson recovered anywhere inside Mr. Simpson's home?
Yes.
Have you seen the pictures of the beige carpet in his bedroom?
Yes.
Have you seen the pictures of the white bedspread on his bed?
Yes.
Are you familiar with the speed at which blood clots, sir?
Yes. There's a range.
And, sir, what is that range?
Objection, Your Honor, beyond the scope of his expertise, no foundation.
Sustained.
Sir, in your expertise on blood spatter patterns and bloodstain interpretation, have you studied the rate at which blood clots and what role that plays in providing features of particular bloodstains?
Yes.
And for how long have you studied that fact, sir?
Since we began drawing blood in 1954, if we didn't have a anticoagulant, it would always clot, of course.
And what is the significance, and what is that range for clotting?
Same objection, Your Honor, there is no foundation of expertise.
Overruled.
The normal range, not only in our experiments and observations, but in the published literature, is generally between 3 and 6 minutes. If someone is hemophiliac, then of course it will be much, much longer, if at all.
And what is the significance of your knowledge of the clotting factor in giving an opinion on whether or not the blood stains seen on those socks could have been made had Mr. Simpson come home with Nicole Brown Simpson's blood on his hands when he took off those socks?
Objection, Your Honor. Objection. No foundation, it's called for speculation, and it seems facts not evidence.
Overruled.
I would expect to see traces of clot material on the surface because it would not penetrate into the fabric. But the amount of clot material on a dark surface like that could be the first thing removed if a testing was made. It would not necessarily bond as quickly as the blood that's saturated and soaked into the fabric.
And in the notes that you have reviewed by Greg Matheson and Mr. Sims of their observations of the stain on the outside surface of the sock, do any of them mention seeing any clot-like material?
Not that I'm aware of.
Yesterday, Ms. Clark asked you whether or not the surface of the stains that you saw on the ankle could have happened, withdrawn. I'll rephrase it. Yesterday, Ms. Clark asked you whether or not the surface stain you saw, the surface one of the sock, could have been made by contact at the Bundy crime scene. Is there anything about not just the stain you saw on surface one, but the stain you saw on surface 2 and surface 3, which would indicate to you that it couldn't have happened that way.
Yes.
And what is that, sir?
The red balls on, the red balls that were on the inside on surface 3, if blood and if transferred from surface 2, would have to be transferred by a moist or wet stain. And that wet, moist stain could not persist for a period of time. 6 minutes, 7 minutes, 8 minutes would be far beyond the drying time.
Sustained. Answer is completely stricken.
Professor McDonald,
Excuse me.
With-
Over at the sidebar with the court reporter. Ladies and gentlemen, would you step into the jury room, please? Zach, stay there. All right, thank you, counsel. Be seated. What was that about?
Oh, I'm sorry. Your Honor, when Professor McDonald has a second reason, aside from drying, as to why, when you look not just at the surface stain on surface 1, but the surface stains on 2 and 3, why it's inconsistent with Bundy. And the answer would simply be that the stain that you see on surface 3 had to have occurred at a time when there was no ankle in the sock. And that is the answer that I was looking for. That is the answer that he had told me this morning. I knew full well what the court's ruling was with respect to the other, and I was very careful about it. And as you may have noticed, I was basically done, and I realized that there was one other way that I could still deal with the same hypothetical without even going into drying, but just to have him say that there'd be no ankle there. And that's the answer that I was looking for.
It's not the answer we got.
That I understand, Your Honor, and I'm sorry about that, but that was not my intention at that time. I heard the court's ruling very clearly, and I fully expected this witness to give the other answer. You can inquire of the witness, Your Honor. I've no problem with it. There were two separate grounds for the opinion, and I at that time expected him to simply articulate the second ground based on the court's ruling.
All right, I've stricken the answer. I take it this is going to be your last question?
Yes.
Have you heard, Your Honor?
Yes.
Also, Your Honor, before we have the jury, can I instruct the witness to so limit his answers so we don't have any additional problem?
He's been present for our discussion. I assume he has understood what we've just discussed.
Thank you, Your Honor.
Ms. Clark.
But that's the very problem, and I'm sure that Mr. Neufeld informed this witness that he was not to go into the sock drying experiments. This is the fourth time counsel has elicited that response from the witness. I'm not saying counsel's doing it intentionally, but it is happening nonetheless. The witness should be charged with the not. It's a professional witness. This is not some kid off the street who's testifying for the first time. This is 150 times this man has testified. He knows better. And yet 4 times I've had to object to prevent him from testifying to what he knows and counsel knows is inadmissible. And now it's happened again. And I don't know, I don't know when some admonition should be given to the jury, if not now. How many times does this man get to bring into the record or attempt to bring into the record material that the court has determined is inappropriate and inadmissible? How many times before the
Well,
jury is told that this is
I think-
inadmissible?
I think the jury has divined enough that I've stopped the proceedings, asked them to step out, and stricken the answer. I think they got the feeling that it's been inappropriate, and since it's happened 4 times with this witness already, I think they've gotten the message. All right, let's
The other
proceed.
problem is discovery. We
No,
never
you may
were-
not.
We were never informed of the second reason, Your Honor. This is a new one to me. As a matter of fact, the witness conceded on cross-examination that he could not say that surface 1 and surface 3 stains were made at the same time. And now, for the first time, I'm hearing there's a new theory that I was not informed of.
Are you speaking of the clotting business?
No,
I'm,
it's not a new theory, Your Honor. He said, in
Wait,
fact,
counsel, I'm sorry.
I'm sorry, I put,
No, I was speaking with Ms. Clark.
sorry.
I have not heard this new theory that counsel admitted just now was told to him by this witness this morning for the first time. There was an additional reason other than the sock drying experiment. That's the point of discovery, isn't it? That's
is.
why the people asked for the 402 on this witness to begin with. He is testifying to things that no one's heard before, even counsel has heard before this morning. How can we effectively cross-examine someone like this?
All right. As to which point, Ms. Clark?
Well, as to the new theory now about the timing of when stain 3 had to have occurred, this is something new. Initially,
The new theory that it occurred when?
it appears that the witness is now going to attempt to testify that he can say definitively that stains 1 and stains 3 occurred at the same time because stain 3 came from stain 2. That was something that he was not willing to go that far on cross. Apparently he has something new to offer, which counsel just said was explained to him this morning by this witness.
No, but he's already opined that in his opinion, stain 3 came from stain 2. And that obviously because of the way men wear socks, or women for that matter, then obviously if there was a foot in there, it wouldn't happen this way. That's what I think the answer is going to be.
But may I have one moment, Your Honor? Because that would be consistent with what he had said before.
And since
But-
that's a concluding question, I assume it's a wrap-up question.
Well, it's not, but this is a new theory, if what I understand is correct.
No, it's not a new theory.
Can we hear from counsel then? Because
No, it's not a new theory. Their theory is that
that's what counsel said.
3 came from 2, and the
Right.
only way that can happen is if there isn't a foot in it. Even I understand that.
And I understood that too, Your Honor, but here's what
Okay.
counsel said. He said there were 2 separate grounds for the opinion. One, the sock drying experiment, and one...
This is a different theory. All right, let's have the jurors, please. Record to reflect that we've been rejoined by all the members of our jury panel. Mr. Neufeld, do you have any further questions?
Yes. Professor McDonald, based on your observations of surface 1, surface 2, and surface 3 of the sock in question, is it your opinion that the staining of that sock could have happened at the Bundy crime scene?
No.
Why not?
If there was a foot or an ankle in the sock, it could not transfer from surface 2 to 3.
Overruled. Overruled.
Please start again, sir.
The staining that transferred, in my opinion, from surface 2 to surface 3 could not occur if a foot was in the sock.
Thank you very much. No further questions.
Ms. Clark.
But you cannot tell this jury that the stain to surface 2 and the stain to surface 3 occurred at the same time, correct?
That is correct.
Overruled.
And if there are little round balls already formed on surface 2, sir, You cannot rule out the possibility of transfer to surface 3, correct?
Objection as to transfer.
Overruled.
I do not understand the question, I'm sorry.
Okay. Let me ask you more simply. Assume the following hypothetical, sir, that someone is wearing a very thin pair of nylon socks and that they are wet with perspiration, that blood,
Overruled.
that a blood stain is applied to the outer surface around the ankle, that while the blood is still in a wet condition, the socks are left flat on the floor.
Objection assumes again facts not necessary. It's
Overruled.
speculation.
Overruled.
The socks are left flat on the floor while that blood stain is still wet. Could such a set of facts, sir, cause the little balls to appear on the surface 3 that such as you observed in this case?
Yes, under those conditions.
You indicated, sir, that the little balls that you saw on surface 3 would have to have been there before the February 16th examination by Dr. Henry Lee. Isn't that what you said?
Yes, they would have to be.
But to the best of your knowledge, there are no photographs that depict any of those little balls taken on February 16th, 1995 during Dr. Henry Lee's examination, correct?
That's correct.
And Dr. Lee did instruct or direct the photographs that were taken on April 2nd, 1995, did he not?
Yes.
You indicated that the performance of a phenol test could only have caused those little balls to appear on surface 3 if there was an abundance of liquid. You recall that testimony, sir?
Yes.
Nevertheless, the volume of the little balls that you saw is so microscopic that they could not be seen with the naked eye. Isn't that correct?
That is correct.
And yet the drop of blood on the outer surface of surface 1, you estimated at 50 to 60 microliters. Isn't that right?
That is correct.
An easily observed volume of blood, would it not be?
Yes,
Under high-intensity light on those dark socks, anyway.
certainly.
Nevertheless, a drop of blood of that quantity, 50 to 60 microliters, would be easy for us to see with the naked eye. Isn't that correct?
Not under this illumination, but if you had high-intensity illumination, an average person could see it without anything more than a magnifying glass.
But on those black socks, sir, if someone under normal lighting conditions was not looking for blood, then that amount of blood, 50 to 60 microliters, could be easily missed, could it not?
Objection beyond the scope, of course. Of redirect, I'm sorry.
Sustained.
Okay, now the dot on the paper where we saw the sampling phase of the phenolphthalein test on the socks could be water dripping, could it not, sir?
Objection, also speculation.
Sustained.
Well, sir, you don't know. You don't know how that drop got to be there. Isn't that correct?
Objection, Your Honor. Again, speculation.
Overruled.
It didn't get there by dripping, at least if it did, the paper was at an angle because it's an oval or an ellipse and not a round spot, which is what happens when a liquid strikes a flat surface.
Nevertheless, you do not know how that water came to be there. Isn't that correct?
That's correct.
You don't know if it's because they were dabbing off excess water or if water was just dripping from a very wet swab. Isn't that right?
Sustained.
Now, you examined these socks for the first time 10 months after their collection on April 2nd, 1995.
I examined them on that date, yes.
Did you perform any test on the material of those socks to determine whether you could examine them 10 months after they were perspired into and detect the perspiration on them?
No.
Did you perform any experiments on those socks to determine whether perspiration would absorb all the way through for the purpose of being able to detect that perspiration later on?
Well,
Yes or no,
First-
Don? Yes, no.
no, I
Mr.
didn't do any
McDonald.
tests, no.
Now, sir, you're aware of Dr. Heisinger's testimony, are you not, that someone who cuts themselves the blood can clot, unclot, and reclot again?
I'm not aware of that, no.
Would that surprise you, sir?
It would surprise me greatly if blood unclotted, there might be additional blood added to an existing clot, but that would be fresh blood. I've never heard of blood unclotting as such.
Let me be more clear. If someone has a cut on their finger, which is bleeding and then clots, can movement of the finger, in your opinion, cause that blood to unclot and bleed fresh?
No, you can move.
Your Honor, I don't believe it's the form of the question.
Sustain, rephrase the question.
Yes. Are you aware of Dr. Heisinger's testimony to the effect, sir, that a cut can bleed and then clot, and through movement and activity, unclot and bleed again?
Counsel, you're using the term unclot.
Unclot.
You're talking perhaps the clot breaks, perhaps the clot is wiped away,
Right.
the wound starts to bleed again with fresh blood.
You can have fresh blood coming from a wound that is previously clotted if you remove the obstruction, which would be the clot or scab.
In which case someone would bleed, stop bleeding, bleed again, correct?
They could, yes. Under that mechanism, they would.
Now, sir, you testified concerning the fact that you saw the photographs of the Rockingham address and saw no blood on the light switch, and no blood on the bedspread, and no blood on the carpets.
Counsel, I sustain the objection to that.
No. Not to
Yes, I
those.
do.
Okay.
To part of that, I sustain the objection. Allowed carpeting in the bedspread.
But not the light switch? Is that it? All right. You testified that you saw no blood on the carpet and no blood on the bedspread. Is that correct?
Overruled.
I didn't observe the carpet until much later. The photographs of the carpet I observed, and the bedspread, but I didn't observe the bedspread itself.
Okay. So you observed photographs of those items, correct?
That is correct.
You have testified, sir, previously that the absence of blood does not necessarily mean that there is non-participation in the crime. Isn't that correct?
Absence of blood on a person, yes.
Well, how would the blood, sir, in your opinion, have gotten to the bedspread or the carpet if not from the person of the murderer?
As I understand.
Sustain. Rephrase
Sir-
the question.
Sir, if you were to see blood on the bedspread or on a carpet in the room of the murderer, you would expect that that would come from the clothing or the body of the murderer itself, would you not?
Objection as to her characterization using the word murderer.
Overruled.
Again, I would expect to see transfers if you have blood on something and you touch something else. But I can't do more than speculate that if a person has blood on them and they get into a room, they may transfer it when it isn't there.
Sir, the question I asked you was a very simple one. If a murderer commits a murder, gets blood on him, then goes back to his room, the mechanism of transfer, if you find blood in the room, would be himself, his clothing, his body, correct?
Yes.
You have
Totally.
previously testified, sir, that the absence of blood on a perpetrator does not indicate non-participation in a violent act, correct?
That is correct.
And when we discussed this before, you indicated as well that although attorneys may want to argue that the absence of blood on their client indicates that he did not commit the bloody act, you have advised them that that is not the case, that that is a misconception, have you not?
Objection on the minute irrelevance to what he advised other lawyers.
Overruled.
I've said that there are exceptions to every rule. It is possible to commit a crime and not get blood on you. Most often, you will see clothing that has no blood on it and assume that the person did not participate. But we'd rather explain seeing the blood and try to establish the mechanism it got there and speculate why it did not. But that is the basis of that article.
Which is that you must interpret what you see and not what you do not see.
Correct.
And in that article, sir, do you not say,
Your Honor, I'm going to object this beyond the scope, and if
Sustain.
sir, isn't it true that people will wear, in your experience, protective clothing such as gloves to prevent getting blood on them.
Objection beyond the scope of the direct and
Sustain.
redirect examination.
Sustain.
Isn't that? Nothing. I have nothing for you.
Well, I have two questions, but I'd like a sidebar first before I ask the questions, and I want to finish the witness this morning if we may.
As would I.
Thank you.
Thank you, counsel.
Thank
Proceed.
you. Professor McDonald, prosecutor asked you a few questions about whether or not you had done any experiments on the socks to test for the presence of perspiration at an earlier time. Are any such experiments possible?
Objection. That calls for speculation, Your Honor.
Overruled.
Certainly, they're possible.
What would the experiment be?
You'd have to get someone exerting themselves to the point where they perspired profusely to soak through from the inside to the outside of the sock.
In addition to experiments, sir, can somebody who is trained make an assessment on whether or not those socks were soaked in perspiration at about the time that the blood was put on them?
Objection. Speculation.
Overruled.
Beyond the
Yes.
scope of expertise, Your Honor.
Overruled.
And did you do that, sir?
I examined the photograph again, which showed very clear staining and no evidence of dilution or diffusion.
Objection is speculation. Again,
Overruled.
beyond expertise.
Overruled.
And had there been extensive perspiration, would there be evidence of diffusion?
I would,
Speculation, Your Honor.
Overruled.
Foundation.
Overruled.
I would expect to see it, yes.
Ms. Clark just asked you another question about socks being taken off when they're wet in the bedroom. From what you know about the case and your observations of the socks, sir, do you have any reason to believe that the socks were wet at the time they were removed in that bedroom?
Sustain.
Nothing further, Your Honor.
Anything further? All right, Mr. McDonald, thank you very much, sir. You're excused. All right, ladies and gentlemen, we'll take our recess for the afternoon session. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. We'll stand in recess until 1 p.m. And counsel, if you recollect, we have an early recess today at 3:45 for a juror appointment, but we do have some legal issues to take up. Sure. All right, back on the record in the Simpson matter. All parties are again present. All right, are we ready to proceed with the next witness?
Your Honor, as I mentioned to you yesterday, because of the matter involving Tracy Savage and Michelle Kessler, the only other testimony we have this afternoon will be the reading of the grand jury testimony of Mr. Paratus, then playing the videotape of the preliminary hearing testimony of Mr. Paratus, and that we will resume with live testimony tomorrow morning with Dr. John Gerdes. I need to know from you, though, because I have to get Mr. Scheck here, when do you want to hear argument on that contamination motion? I'll have someone call where he is. He's over on the west side of town. He can be here in 30 minutes. But I asked you before to make that the last order of business as opposed to the first.
All right, I would suggest we do it after we've concluded all the other matters today, this afternoon.
Okay. All right.
And from my recollection of the tape recording or the grand jury testimony, that would probably only take, what, 8 or 10 minutes?
There are two gentlemen who will read the grand jury testimony, which should take, I would say, less than 3 or 4 minutes. And then there's the playing of the tape, which should take less than 10 minutes. And then I believe you have the Bosco matter. And then we would have Mr. Scheck and Mr. Clark on the contamination
On
matter.
the Gerdes matter. All right. Sounds like a plan.
Is that consistent with? Okay.
How do you propose to proceed at this point, then?
Well, Your Honor, I would propose that we need someone to play Marcia Clark, Your Honor, and I searched all around, and I came up with Mr. Douglas. We'll do that, I believe, and Mr. Scheck will be Mr. Paratus, the nurse. Well, Mr. Strike that. Mr. Blazer, Bob Blazer, will be Mr. Paratus.
All right.
We're ready to proceed if you are, Your Honor.
All right.
Mr.
Goldberg.
From the witness stand, okay, why don't we take the, that's fine.
Your Honor, I don't know whether they were planning on breaking before supposedly playing this tape of the preliminary hearing, but obviously that would be something that would have to be screened. We don't know whether there are television commentators interrupting it. And of course, the people would object to the using of the videotape at all, since that is not the official court record. The official court record is the written transcript. And there is no exception that I am aware of that would allow a videotape that was created by a third party who is not an officer of the court, that kind of evidence to be allowed in without any foundation.
All right. Wants to address the use of the videotape for the purposes of prior recorded testimony. Mr. Goldberg, are you indicating to the court that you have you have not seen this tape recording before?
I haven't seen what they propose to play to the jury.
Your Honor, since this is,
I'm sorry. How many lawyers are going to have to talk about this?
I am. He's on this issue.
All right.
There. Your Honor, Ms. Clark called as a witness at the preliminary hearing Mr. Nurse Paratus, and I cross-examined him. It was in the courtroom setting. It was under oath. It was done under the same settings that you have here. And I don't think there is any question whatsoever of the accuracy of the, I'm sorry, Ms. Clark is trying to say something?
I'm whispering to Mr. Goldberg.
I'm sorry, I thought you were whispering to me. Excuse me. That I don't think there is any objection, unless Ms. Clark wants to represent to Your Honor that those questions that she asked or the answers that were given by Mr. Paradas are not accurate. Clearly, this is the best way for the jury to see exactly what has happened in the testimony. This is live testimony under oath, and it is much better than the transcript because the words are not coming from people who are reading the words are coming from the witness, just as if you did a videotape deposition. So I think this is an issue that
You're trying to say it's a form over substance objection. Is what you're trying
exactly,
to say.
exactly. Thank you, Your Honor.
Mr. Goldberg?
Well, it isn't a form over substance issue. I mean, we may arrive at the time where we commonly use videotapes, maybe hopefully in addition to court reporters for the purposes of recording what happens in a court, but we have not arrived at that point yet. And in instances where a videotape has been authorized by the court, if it had been authorized by the court, what Your Honor would have undoubtedly directed the videographer to do would be to exclusively photograph the witness. But since the only photography we have of these proceedings is done by people who are not within the court's direct control, they sometimes show the witness, they sometimes show the attorney, they sometimes pan over to the defendant to capture his reaction or the reactions of other people that are sitting at counsel table, and occasionally pan over to Your Honor to capture the court's reaction. All of those kinds of things would be things that the court would not permit if the videographer were under the court's direct control. They are editorializations of what is happening in court that are not proper. And I think that this whole issue is more significant than simply relating to the question of Fano Paradas' testimony, because I would assume, as perhaps has already been brought to the court's attention, that one or both of the parties might want to use videotape portions of the trial in closing argument. I think we get into some of the same problems there as well, given that we do not have an official record and we have a situation where we don't know exactly who the camera was focusing on unless we have previewed that particular video snippet. And we also have times, I believe, although I'm not positive, where not everything has been captured on tape with respect to a single witness, where the news organization may have interrupted for television commercials. I'm not 100% positive that every single witness, 100% of that witness's testimony is on tape. So there are some problems that this presents further down the road when we get to closing argument as well, Your Honor.
All right, let's look at, I had not contemplated the various editorial issues, what the videotape actually shows and how much is actually Mr. Paradas and how much is extraneous matters. So this tape is only about 8 or 10 minutes. Let's see the tape.
The tape you're going to see, Your Honor, has the one redaction as ordered by the court, and that there was one objection made by Marcia Clark, which was sustained by the court. Otherwise, it is the verbatim tape.
All right, let's see it.
It's the clerk, sir, and raise your right hand.
Do you solemnly swear the testimony you're about to give will cause not any before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Right up here, sir.
State and spell your name for the record.
Ronald Paradas, T-H-A-N-O-P-E-R-A-T-I-S.
You may inquire.
Thank you, Honor. Mr. Paradas, sir, can you tell us what you do for a living?
I'm a registered nurse.
You're a registered nurse?
Yes, ma'am.
And are you qualified to draw blood from people?
Yes,
How long have you been a registered nurse?
about 40 years.
And where are you employed as a registered nurse?
Parker Center Jail.
At Parker Center Jail? Is that yes?
Yes, ma'am.
Were you so employed on the date of June the 13th, 1994?
Yes,
Have you received some training in a medically approved manner of taking blood from people in a way that does not contaminate the blood?
yes,
And did you, on June the 13th, 1994, remove a blood sample from someone you recognize in court today?
yes.
Could you please point that person out?
The gentleman over there.
And what's he wearing right now?
I didn't hear you.
What is he wearing right now, for the record?
A black suit.
Are you referring to the defendant here, Mr. Simpson?
Oh, the defense. Maybe I misunderstood you.
Yes, who are you referring to that you took blood from in this court?
Oh, yes, the defendant.
Indicating Mr. Simpson.
And how did you do that?
Oh, I put a tourniquet on his arm and cleaned the arm with Zephyrin and took a syringe with a needle and put through the blood and put the blood into a test tube.
Was that a sterile test tube?
Yes, ma'am.
And how did you seal the test tube?
The tube was sealed. It had a rubber stopper on it.
It already had a rubber stopper
Yes.
on it? How did you get the blood into it?
Stuck the needle into it and injected it.
And then you just withdrew the needle?
Then went through the needle with the syringe.
And did that leave the test tube then secure with the blood in it?
Yes.
And what did you do with that vial of blood?
I handed the tube to Detective Van Adder.
Thank you, sir. I have nothing further.
Mr. Shapiro?
Do you remember, sir, which arm you drew the blood from?
The right arm.
Did you make any observations of any injuries of Mr. Simpson at the time?
I'm sorry?
Did you observe any injuries on Mr. Simpson at the time you withdrew the blood?
Not at that time, no.
At some time, did you?
After Mr. Simpson, after I put a bandage on Mr. Simpson's arm, I was asked, I can't remember if it was by Mr. Simpson or one of the detectives, if I would dress a wound on his finger.
And did you do that?
Yes, sir.
Where was the wound?
It was on his left hand, on his left middle finger.
Did you examine the wound?
Just a cursory examination. I just looked at it and I cleaned it, which is what we routinely do. Then I put a dressing on it.
Did you determine the age of the wound?
Not really. It was a little difficult to determine the age. It looked like between 12 and 24 hours. But I really couldn't say.
Did you ascertain the cause of the wound?
No. It just looked like a little small cut.
How much blood did you withdraw from Mr. Simpson?
Approximately 8 cc's.
You say approximately. You did not measure the amount?
Well, it could have been 7.9 or it could have been 8.1. And I just looked at the syringe and looked at about 8 cc's. I went through the needle from his arm.
Nobody asked you to take a precise amount of
No.
blood? And you did not record the amount of blood you took?
No, it's just routinely, that's about the amount I usually draw.
And you do this on a routine basis every day? Do you do this every day in the jail, take blood?
Oh, whenever, not for this sort of thing, it's usually for alcohol, blood alcohol.
But you do take blood on a
Yes.
regular basis? You take the same amount of blood?
Yes.
Where did you get the tube from that you put the blood into?
We have a drawer in the dispensary that has tubes in it. And I asked Detective Van Adder to go to that drawer, take the tube out with the purple top, and put Mr. Simpson's name on it and the date, and then hand it to me.
Are there any lot numbers on the tubes that you used?
I believe there are.
Did you record the lot?
No, we don't record that.
Did you record any information as to an inventory regarding the tube that was used to save this blood?
No, it's not a routine procedure that we do.
Did you put any preservative in the tube?
The preservative was already in the tube.
Did you check that before you put
Well,
Mr.
it's-
Simpson's blood in?
It's in there, and it's understood that it's in there. and this preservative is called EDTA, and I don't know what those initials mean.
Did you put the preservative?
No, it's in there.
Did you see someone put it in?
No, they come that way.
Did you shake the blood after you put it into
Yes.
the tube? For how long did you shake it?
For about 10 seconds.
How did you shake it?
Just over and over like this.
The director was making a gesture with his hand as though it was a fist, something in it, and turning it palm down, palm up.
All right.
Have you ever seen that blood sample again?
No,
Do you know what Detective Van Adder did with that blood sample?
I don't know. I have an idea what it's supposed to be done with, but I don't know what he did with it.
Did you see what he did with it?
Well, he put it in an envelope.
What kind of envelope?
A gray envelope that has an affidavit on it that I signed.
A gray envelope?
Yes,
And it had an affidavit?
yes.
What did the affidavit say?
It refers to the fact that I drew the blood on such and such a date, and I handed it to Detective Van Adder.
Did you get a copy of that affidavit?
No, that affidavit goes with the officer that takes the blood.
Did you indicate on that affidavit how much blood you drew?
No.
Yes.
A document here that's medical records for persons in custody. Is this what you refer to as an affidavit?
Well, why don't you show it to the witness now?
Yes, could you show it to the witness so he knows exactly what you're referring to?
This is called a medical treatment record.
That's not the affidavit?
No, sir.
Let's see if we have the affidavit. Do you have the affidavit? Does the affidavit remain on the envelope, do you know?
It is printed on the envelope. It's a gray envelope that all blood goes into. There's an affidavit on it.
Recall what time you drew this blood?
Yes, sir, blood drawn, at 2:30. I think I have it on there as 14:30.
Was there a physician on duty?
No, sir.
Are there any physicians at the jail?
Yes.
Nothing further comes to your
Ms. Clark, anything further?
One more question, Your Honor.
You always have fun.
I know. It might be prosecutor's last word. Sir, do you have knowledge of whether those vials that you use to withdraw blood are prepackaged vials?
Yes, they are prepackaged.
Are they all the same size?
Yes, those are about 10 cc vials. We have some smaller ones, but we don't use them.
Mr. Shapiro? Thank you, sir. You may step down. Please do not discuss your testimony with anyone.
All right, Mr. Bancroft, were you the videographer on that?
Yes, Your Honor.
All right. All right, the court has observed the videotape, which I think we should mark defendants next in order if we have not already. $12.83. And Mr. Goldberg, do you have any further argument in opposition to the use of the videotape?
Your Honor, the problem with the videotape, as the court may have noticed, in particular, is that a couple times it pans over to the defendant. Of course, it also pans over to the attorneys, although I'm not certain that that particular feature is prejudicial to us per se in this particular instance. Showing the defendant may be. Similarly, showing the victim's family may be somewhat prejudicial or at least unnecessary as far as the defense is concerned. So if the court were inclined, and we think that the court should, if this videotape is going to be used, cut out the pans to the defendant, that it would also be fair to cut out the pans to the audience as well. I don't think that the people, as a tactical matter, are particularly prejudiced if the court were to make those deletions in showing this videotape. But the concern that we do have is that if the court allows this videotape, the court will allow other videotapes, and we will always be confronted with the same kinds of problems that the court saw here. For example, if in the closing argument they were to be used, and the defense were to say, well, look at how this witness reacted when they were asked such and such, and look at his demeanor. And then the people wanted to put that into context by showing some other snippet, but that snippet was either not captured at all, or during that part of the testimony they were panning to the defendant or to one of the attorneys. That would simply be fundamentally unfair. And it would not give us the opportunity, or if we were to do it, would not give the defense the opportunity necessarily to try to use the remaining portions of the videotape to place into context.
Well, that's a different issue, counsel. Let's concentrate on
Well,
this.
because I am concerned, I'm very concerned that this is going to set a precedent, and that if the court is going to allow this videotape in,
Well,
notwithstanding...
there's a huge difference between allowing something as substantive evidence and allowing its use in argument, don't you think?
I think that there's a difference, but the principle is the same, and that is what can we use when we are quoting the court record and the court transcript? What is the appropriate medium that we are using? Is it a videotape, or is it what it has always historically been? That is what the court reporter has generated. So the underlying principle is the same, and therefore we are concerned that if the court rules today that for evidentiary purposes we can use the videotape, that the court is going to rule the same at the time of the closing arguments, and suggest that for argument we can also use the videotape. So my point is, Your Honor, although I don't think that the prosecution is necessarily prejudiced in this instance through the use of this tape, even though legally it probably isn't authorized, we are not prejudiced if the deletions that I referred to are made. We still are very concerned that this precedent might allow the court to then allow either party or both parties to use videotape segments in the closing arguments that could be prejudicial to both sides.
All right, well, Mr. Goldberg, you should rest assured that I see those as separate and distinct issues. All right, Mr. Shapiro, any further comment?
Your Honor, I think the videographer captured the demeanor of the witness that you would not get if the testimony was read by parties portraying their testimony. The jury, when they sit in the courtroom, not only sees Mr. Simpson and the lawyers, but sees the audience. I saw no reactions that are unusual either from Mr. Simpson or from the Goldman family, and we have no objection and think the best way for the jury to judge this witness's credibility and what this witness is called to testify for on behalf of the defense is fairly and accurately best depicted by this video. Thank you.
All right, thank you, counsel. I agree. I think one of the most important things is for a jury to see as well as hear a witness testify, and this is one of the advances in technology that is beneficial to the truth-finding process, so I'll allow the use of the videotape. If the prosecution has any discrepancies from the official court transcript that they want to challenge with during their presentation of their case in rebuttal, they're entitled to do so. All right, let's have the jury, please.
I'm not going to edit either.
No.
the court have the instruction to read to the jury concerning the admissibility of the testimony?
No, I don't.
May I get it for you, Your Honor? I'm
Which
sorry.
Calgic is that? I'm sorry. I forgot about that.
You're talking about the witness being not available?
Yeah, there's a witness unavailable.
We'll get that.
I think that it ought to be given to the
Because
jury.
you
Now, if I
made
can go
that
and pull
finding.
it.
May I get back in your chance to get the counsel, the prosecutor?
May I assist, Mr. Cochran?
You may.
Thank you.
All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. All right, ladies and gentlemen, good afternoon. Sorry for that short delay. We are now going to present to you testimony from a witness who is presently unavailable, but who has presented testimony in other proceedings. You are instructed that testimony given by a witness at a prior proceeding who is unavailable at this trial will be presented to you both in the form of a videotape of that witness's testimony at the preliminary hearing and from the reporter's transcript of that proceeding. You must consider such testimony as if it had been given before you in this trial. All right, let's proceed. All right, which matter do you wish to present first? All right, this will be the grand jury testimony from June the 22nd, 1994, is that correct?
Yes, Your Honor.
And counsel, Mr. Blazer, you are going to read the part of the witness, is that correct?
I am, Your Honor.
And Mr. Carl Douglas, you are going to play the part of the examiner, Ms. Clark, is that
I'll
correct?
try, Your Honor, yes.
All right, you may proceed.
First, the oath, Your Honor, from the
Yes.
foreperson. Thano Pradas, please raise your right hand.
Excuse me, let's start. No, we start with, you don't need to do that, we just... Let's start with Ms. Clark, people call Thano Paradas.
Thank you, Your Honor. The people call Thano Paradas. We have to add him to the list. Thanopratis. The foreperson then says, Thano Paradas, please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now pending before the grand jury of the County of Los Angeles shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. Mr. Paradas, please state and spell your full name, speaking directly into the microphone.
Thano M. Paradas, T-H-A-N-O-M-P-E-R-A-T-I-S.
The foreperson says you may, thank you, you may proceed by Ms. Clark. Thank you. Tell us what you do for a living, Mr. Paradas.
I'm a registered nurse.
Where do you work?
Parker Center Jail.
Excuse me, counsel. Could you gentlemen slow down, please?
Surely.
Thank you.
As a registered nurse, do you have some training?
Sorry?
Do you have a hard time hearing me, sir? Can you hear me now?
Yeah, that's better.
What is your training to become a nurse?
I went to nursing school.
Did you receive a degree as a registered nurse?
Yes, ma'am.
As such, are you qualified to remove blood from people in a medically approved manner?
Yes.
In that part of the duties you perform,
Counsel, reread that, please.
is that part of the duties you perform as the nurse at the jail dispensary at Parker Center here in Los Angeles County?
Yes, it is.
And on June 13th, 1994, were you working that day, sir?
Yes, ma'am.
At Parker Center in your usual capacity as a registered nurse?
Yes.
Were you requested to remove blood from the arm of a person by the name of Mr. Orenthal James Simpson?
Not quite with that. The initials were O.J. Simpson, yes.
Did you remove a blood sample from that person
Yes, I did.
on June 13?
Yes.
I will show you Peoples 23, and you tell me if that's the person you removed blood from.
Yes, it is.
Can you describe for us what is the method by which you removed blood from Mr. Simpson?
I put a tourniquet on his arm, cleaned the site with aqueous Zephyrin, and put a 10 cc syringe with about a number 20 needle in the vein in his arm, and I withdrew about 8 cc's of blood. And I then put the blood into a test tube that had a preservative called EDTA, and then handed it to the officer, to the detective, and then put a dressing on him.
On the arm?
Yes.
Approximately how much blood did you remove?
Approximately 8 cc's.
And the manner in which you removed that blood, did it avoid any contamination of the blood?
Oh, definitely.
And the manner in which you packaged it, was it also sealed to prevent any contamination?
Yes, ma'am.
Did you then put it in some kind of a package?
I handed it to one of the detectives who put it into a large gray envelope.
Did you hand it to Detective Philip Van Adder?
Van Adder, yes.
I have nothing further.
Thank you, gentlemen. All right, ladies and gentlemen, we are next going to exhibit to you a videotape of Mr. Paradas' testimony during the preliminary hearing. You will notice that there is one blip in the tape. It is an edit of some material that I ordered removed from the tape before it was played to you. So if you see that blip, that's what that is. All right, and Mr. Who's presenting this? Mr. Shapiro? Yes. We need a statement regarding date and time of the proffered evidence.
Yes, Your Honor, we called as a witness July 7th, 1994, at the preliminary hearing in this matter, Nurse Thano Paradas.
All right, July 7 is a prosecution witness.
I'm sorry, the prosecution called as a witness at
All right,
the
July
preliminary
7.
hearing. And called by Ms. Clark, was cross-examined by myself.
All right, let's proceed.
Thank you.
Face the clerk, sir, and raise your right hand.
You do solemnly swear the testimony you're about to give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Please be seated.
Right up here, sir.
Thano Paratis, ThanoPeratis.
You may inquire.
Thank you, Howard. Mr. Paradas, sir, can you tell us what you do for a living?
I'm a registered nurse.
You're a registered nurse?
Yes, ma'am.
And are you qualified to draw blood from people?
Yes,
How long have you been a registered nurse?
about 40 years.
And where are you employed as a registered nurse?
Parker Center Jail.
At Parker Center Jail? Is that yes?
Yes, ma'am.
Were you so employed on the date of June the 13th, 1994?
Yes,
Have you received some training in a medically approved manner of taking blood from people in a way that does not contaminate the blood?
yes,
And did you, on June the 13th, 1994, remove a blood sample from someone you recognize in court today?
yes.
Could you please point that person out?
The gentleman over there.
And what's he wearing right now?
I can hear you.
What is he wearing right now, for the record?
A black suit.
Are you referring to the defendant here, Mr. Simpson?
Oh, the defendant. Maybe I misunderstood you.
Yes, who are you referring to that you took blood from in this court?
Oh, yes, the defendant.
Indicating Mr. Simpson.
And how did you do that?
Oh, I put a tourniquet on his arm and cleaned the arm with Zephyrin and took a syringe with a needle and withdrew the blood and put the blood into a test tube.
Was that a sterile test tube?
Yes, ma'am.
And how did you seal the test tube?
The tube was sealed. It has a rubber stopper on it.
It already had a rubber stopper
Yes.
on it? How did you get the blood into it?
I stuck the needle into it and injected it.
And then you just withdrew the needle?
Then withdrew the needle with a syringe.
And did that leave the test tube then secure with the blood in it?
Yes.
And what did you do with that vial of blood?
I handed the tube to Detective Van Adder.
Thank you, sir. I have nothing further.
Mr. Shapiro.
Do you remember, sir, which arm you drew the blood from?
The right arm.
Did you make any observations of any injuries of Mr. Simpson at the time?
I'm sorry?
Did you observe any injuries on Mr. Simpson at the time you withdrew the blood?
Not at that time, no.
At some time, did you?
After Mr. Simpson, after I put a bandage up Mr. Simpson's arm, I was asked, I can't remember if it was by Mr. Simpson or one of the detectives, if I would dress a wound on his finger.
And did you do that?
Yes, sir.
Where was the wound?
It was on his left hand, on his left middle finger.
Did you examine the wound?
Just a cursory examination. I just looked at it and I cleaned it, which is what we routinely do. Then I put a dressing on it.
Did you determine the age of the wound?
Not really. It was a little difficult to determine the age. It looked like between 12 and 24 hours. But I really couldn't say.
Did you ascertain the cause of the wound?
No. It just looked like a little small cut.
How much blood did you withdraw from Mr. Simpson?
Approximately 8 cc's.
Did you say approximately? You did not measure the amount?
Well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and looked at about 8 cc's. I withdrew the needle from his arm.
Nobody asked you to take a precise amount
No.
of blood? And you did not record the amount of blood you took?
No. It's just routinely, that's about the amount I usually draw.
And you do this on a routine basis every day? Do you do this every day in the jail, take blood?
Oh, whenever, not for this sort of thing, it's usually for alcohol, blood alcohol.
But you do take blood on a
Yes.
regular basis? And you take the same amount of blood?
Yes.
Where did you get the tube from that you put the blood into?
We have a drawer in the dispensary that has tubes in it. And I asked Detective Van Adder to go to that drawer, take the tube out with the purple top, and put Mr. Simpson's name on it and the date, and then hand it to me.
Are there any lot numbers on the tubes that you use?
I believe there are.
Did you record the lot?
No, we don't record that.
Did you record any information as to an inventory regarding the tube that was used to save this blood?
No, it's not a routine procedure that we do.
Did you put any preservative in the tube?
The preservative was already in the tube.
Did you check that before you put
Well,
Mr.
it's-
Simpson's blood in?
It's in there, and it's understood that it's in there. And this preservative is called EDTA, and I don't know what those initials mean.
Did you put the preservative in?
No, it's in there.
Did you see someone put it in?
No, they come that way.
Did you shake the blood after you put it into
Yes.
the tube? For how long did you shake it?
For about 10 seconds,
How did you shake it?
just over and over like this.
For the record, the witness was making a gesture with his hand, it was a fist, something in it, and turning it calm down, calm up.
All right.
Have you ever seen that blood sample again?
No,
Do you know what Detective Van Adder did with that blood sample?
I don't know. I have an idea what is supposed to be done with it, but I don't know what he did with it.
Did you see what he did with it?
Well, he put it in an envelope.
What kind of envelope did he put
A gray envelope that has an affidavit on it that I signed.
A gray envelope?
Yes,
And it had an affidavit?
yes.
What did the affidavit say?
Well, it refers to the fact that I drew the blood on such and such a date, and I handed it to Detective Van Adder.
Did you get a copy of that affidavit?
No, that affidavit goes with the officer that takes the blood.
Did you indicate on that affidavit how much blood you drew?
No.
Yes.
I have a document here that's medical records for persons in custody. Is this what you referred to as an affidavit?
Well, why don't you show it to the witness?
Yes, could you show it to the witness so he knows exactly what you're referring to? Please?
This is called a medical treatment record.
That's not the affidavit?
No, sir.
Let's see if we have the affidavit. Do you have the affidavit? Does the affidavit remain on the envelope, do you know?
It is printed on the envelope. It's a gray envelope that all blood goes into. There's an affidavit on
Do you
it.
recall what time you drew this blood?
Yes, sir. Blood drawn at 2:30. I think I have it on there as 14:30.
Was there a physician on duty?
No, sir.
Are there any physicians at the jail?
Yes.
I have nothing further. Thank you.
Ms. Clark, anything further?
What question do you have?
You always have fun.
I know. It might be a prosecutor's last word thing. Sir, do you have knowledge of whether those vials that you use to withdraw blood are prepackaged vials?
Yes, they are prepackaged.
Are they all the same size?
Yes, those are about 10 cc vials. We have some smaller ones, but we don't use them.
Mr. Shapiro? Thank you, sir. You may step down. Please do not discuss your testimony with anyone.
All right, let me see counsel without the report. Ladies and gentlemen, I have a matter I need to take up out of your presence with the attorneys. Let me ask you to step back into the jury room, and we'll summon you out shortly. Like the jury has withdrawn from the courtroom. Mr. Harris, would you tender the videotape to Mrs. Robertson? We'll mark the transcript of the grand jury testimony of June 22nd, 1994 as defense exhibit next in order 1284, and the videotape will be marked defense 1285. I'm sorry, 1283? All right. Thank you. All right, Mr. Shapiro.
Thank you very much. The next witness we would like to call is Mr. Joseph Bosco. We would like to call him for a very, very specific and limited purpose only. I talked to Mr. Bosco last week. Before he was subpoenaed, he agreed to accept service of subpoena and agreed that the article that he had published, that he had written, that was published in Penthouse magazine in the July issue, truly and accurately reflected a discussion he had, and the relevant part of that article that we wish to present to the jury is as follows: that there has been enough leaking out there to sink Camp OJ if it were on a barge, by the defense and the prosecution alike. But both are pikers compared to the Los Angeles Police Department. It began last summer with the LAPD passing out 9/11 tapes to journalists as if they were courtesy trinkets, welcoming them to town, and reached its nadir with the, quote, DNA sock match story. Of the latter, I know this. Within 2 hours of Judge Ito admonishing the police for, quote, reckless disregard of the truth, LAPD's worst moment to that date, a certain police officer whose leaks had hitherto been mostly accurate and offered with corroboration started calling journalists with the story that blood on the socks found in OJ's bedroom was a DNA match with Nicole's. This time, however, the officer offered no corroboration and became angry and defensive when asked. A number of journalists turned him down. Apparently, KNBC did not, and the rest is ugly history for both the press and the LAPD. We will call him only for the limited purpose of presenting to this jury the relevant testimony that the disinformation that was given was from a badged member of the Los Angeles Police Department who was acting in official capacity and for no other purpose.
Who was acting in an official capacity?
Well, was acting as an active member of the police department.
Right.
I don't think he can say that he was acting in an official capacity. But he was acting as a police officer, and that would be the limited purpose only of calling him.
All right, have you consulted with his counsel?
Yes, I have, and they have no objection with that limitation.
All right, and do we have Ms. Osinski now present?
Yes, she is.
Good afternoon, Your Honor.
All
I'm
right.
sorry, I was not privy to the conversation that just took place.
All right, Mr. Shapiro has just made an offer to the court of his purposes for calling Mr. Bosco. And Mr. Shapiro, would you repeat that for Ms. Osinski's benefit,
Yes.
please?
As I discussed with Ms. Osinski and Mr. Bosco, the limited purpose of calling Mr. Bosco is to authenticate an article that was published in Penthouse magazine that was authored by him that concerns information or disinformation, if you will, that was given to him by a member of the Los Angeles Police Department regarding a match of DNA for that purpose and for no other purpose.
All right, Ms. Osinski, what is the position of your client?
Your Honor, our position is, and it's in our papers, that Mr. Bosco is covered by the Shield Law. He would testify only as to published information. Basically, that would be that he's the author of the article, he's familiar with the article, and that it's a true and fair representation or account of what was said to him. Other than that, he will not testify as to any other information that is not published information as found in that article. And it's my understanding that Mr. Shapiro has indicated that they are willing to limit their questioning to that area. However, I have had no representation from the prosecution that they are also willing to limit any questions that they may have to that area. And therefore, I think that unless we have a stipulation to that effect, I think we need to have a discussion of the issues of the Shield Law or actually make a decision on Mr. Bosco's testimony, if it will be restricted or not. Because we will be asserting the Shield Law as to any questions other than those about published information.
All right, what's the people's position?
Your Honor, first of all, counsel is sort of seems to be trying to ambush the people again, because they know that this whole issue of leaks was subject to two motions that the people wrote, one for Michelle Kessler and one on the issue of the leaks themselves. The defense has written a formal points and authorities. It's been argued by Mr. Ullman. It's been argued by myself. And they had previously represented that this testimony was going to be presented in a 402 type hearing as part of the considerations and the issues that were in front of Your Honor right now as to whether or not you were going to allow any evidence of the so-called leak to be presented, and also whether you were going to allow Michelle Kessler to be cross-examined as to that. So now all of a sudden they say they want right now to put this on in front of the jury, and they have previously not made that representation to the people. I think that all of these issues are currently under submission to the court. And also, I don't think this witness is on their witness list. Excuse me?
All right. Go ahead.
Your Honor, as to the substantive issues, and I don't believe we should be arguing the substantive issues yet, because it's premature, and the court first should make that ruling that the court said it was going to as to whether or not there is relevancy to this whole issue of the so-called leaks at all, which is also a predicate towards determining whether or not the Shield Law applies. But if the court were to somehow, and I don't think the court should do this, I hope Your Honor will not do this, somehow put those issues aside and in effect put the cart before the horse and now introduce this testimony before having ruled as to relevancy, which Your Honor took under submission, I'd like to make the following substantive comments. First of all, under the defense's own theory, they have stated that as to the issue of evidence planting, and they articulated this, and I previously argued this to the court, that leak information would only be relevant if it was made by someone in the Scientific Investigations Division who participated in analyzing the SOX. They said that. I gave that direct quote to the court previously. I don't have their points and authorities down with me right now, but they specifically stated that in framing the issues. Obviously, we can see that if some police officer somewhere, if it indeed was a police officer, found out information, obviously it would be secondhand. Let's try to make this concrete. Let's envision a police officer who happens to work in Parker Center and overheard. I'm making up a scenario just for illustration purposes. Overheard Detective Lang and Detective Van Adder talking in the elevator, and they said that there had already been DNA testing on the SOX. And this police officer immediately ran to the phone and leaked this information to Mr. Bodsko. Or maybe he misunderstood the information that he overheard. What would the relevance of that be? What would the relevance be that this officer, Officer X, had overheard this information and had leaked it? It doesn't go to the issue of planting. It doesn't go to any of the issues that the defense claimed to be relevant. And it isn't relevant under the theories that they specifically articulated in their written papers in front of the court. It just doesn't have anything to do with this case whatsoever. We have argued that even if it were an SID criminalist who was involved, it wouldn't be relevant to this case, because it does not tend to show that that person was involved in planting evidence on the socks. But if it's just some police officer, it's far more tenuous. So it is impossible to conceive of any relevant theory of this evidence. Okay, next. Let's say that Mr. Bodsko gets up on the witness stand and merely authenticates this article, which is what Mr. Shapiro is suggesting be done. First of all, this article has numerous conclusions and opinions in it that are not relevant and not admissible. For example, the opinions that there have been numerous leaks by both sides, and that the Los Angeles Police Department makes the other sides appear to be pikers. And most importantly, he says that this leak was to journalists, that he started calling journalists with the story. So we know for certain that what Mr. Bodsko is referring to here is he is referring to conversations that presumably he has had with other journalists. So we know that at least part of the story is predicated upon double hearsay. In other words, what journalists represented to him, this police officer represented to them. What we don't know is whether all of the story is predicated upon hearsay. In other words, we can't be sure simply upon reading these paragraphs that were read into the record whether simply part of the story is predicated on double hearsay or whether their entire story is predicated upon double hearsay. So we have a hearsay problem that appears to be insurmountable. The next problem that we have legally with this story is we have an authentication problem. Let's imagine that this conversation with Officer X, if there was a conversation, took place over the phone. What the court would require is in order for that conversation to be admissible, the witness who was testifying to the conversation to authenticate the conversation by saying, I spoke to Officer X, I recognized his voice because I've spoken to him on numerous occasions in person, and I recognized the voice over the phone to be the same as that which I've heard in previous conversations. Further, I know this individual to be a police officer with the Los Angeles Police Department because I've seen his badge and his identification, because I've seen him in uniform, or however the case may be. But the point is that authentication would be required, and we don't have any authentication whatsoever here stated in this article. We don't have anything that comes close to being authentication. And then finally, from a legal perspective, the people have a right to cross-examine any witness that gets up on the witness stand that is offered by the defense. And although it has been said that the Shield law is not a privilege, it clearly is analogous to a privilege, and some people have characterized it as being a privilege.
I think the case law is pretty clear that all it is immunity from being held in contempt. That's all it is.
Well, yeah, it's been characterized as being immunity from being held in contempt, and then there's some case authority to indicate that independent of the Shield law, there's also some sort of First Amendment constitutional right to protect confidential information and news sources that could be conceivably analogized to a privilege. But the point is Your Honor, if a witness were to get up on the witness stand and testify, they have waived any privileges that they have to the full extent of relevant cross-examination. For example, let's say a defendant gets up on the witness stand and testifies in a case, and the people want to ask him about 1101B type evidence relating to a pending criminal charge.
This is not real relevant, counsel.
Well, no, I'd like to explain it, Your Honor. Obviously, this is extremely important to the people, and we would like the opportunity to be heard on all the relevant legal issues.
Well, discussing an indirect analogy of cross-examination of a defendant on 1101B evidence is an interesting issue.
Well, the point
But
is
it
that...
has nothing to do with this issue.
No, well, we have California case law that says that we can cross-examine even if the person invokes their Fifth Amendment privilege as to the pending charges because he has waived his privilege to the full extent of relevant cross-examination. And I don't see why that same rule wouldn't be equally applicable in the context of the so-called shield law, whether you're going to call it a privilege or an immunity, that once that witness has gotten up on the witness stand and has testified to anything voluntarily, that the other side has the right to cross-examine him to the full extent of relevant cross-examination, and therefore any privilege or immunity that he would otherwise have has been waived to the full extent of
But your
relevant
analogy
cross-examination.
fails because neither Mr. Bosco or Ms. Savage are here voluntarily.
Well,
Both have filed motions to quash subpoenas. I mean, that's a huge difference in that
it's
thought process.
It's been represented, though, that Mr. Bosco would be willing to authenticate this article voluntarily. And if he did that, our position is that we get to cross-examine him to the full extent of relevant cross-examination. So he can't get up on the witness stand and says, well, everything I say in here is true. Well, Mr. Bosco, how do you know that this person was a police officer? I invoke the shield law. Have you ever talked to this person in person before? I invoke the shield law. Did you recognize his voice? I invoke the shield law. We have to be allowed to cross-examine. The court couldn't permit a situation to stand where a witness got up on the witness stand and testified to certain information and then foreclose the cross-examiner from cross-examining that individual to the full extent of the relevant cross-examination that was opened by his direct testimony. And that's my point, Your Honor. Let me just take a look at this note to see whether there's something else I wanted to bring up. I just point out on the hearsay issue that I previously mentioned that there's obviously no fundamental indicia of reliability or trustworthiness to this article itself.
In fact, wouldn't you say quite the contrary, given the result?
Well, yes, clearly. And aside from the results, Your Honor, there's the issue of whether other journalists would be revealing their sources to a fellow journalist in such sufficient specific detail that he could tell that they were all referring to the same police officer. So there's a lot about this that is unreliable. So in sum, Your Honor, we would ask the court, as the court has previously ruled, to take under submission the issue of relevancy and to first make a ruling as to whether that initial threshold requirement has been met. Then and only then, if the court has made that ruling, do we then need to sort through some of these other very difficult legal issues relating to hearsay, relating to authentication, and relating to the right of the people to cross-examine the witness who is authenticating this kind of material.
All right. Bureau?
Thank you very much, Your Honor. The first issue is whether or not Mr. Bosco can be called to testify and whether or not he can invoke the shield law to prevent his testimony. He has already indicated to me, and his counsel has indicated to me, that as a result of his previously published article, to that extent and to that extent only, he has no legal right to exert the shield law, and therefore that testimony is not protected testimony. Thus, we are limiting our inquiry within the scope of the privilege. We are not going to call Mr. Bosco or ask him anything that would be covered by the Shield law, potentially. And that's all his counsel has suggested. His counsel has not suggested that the people be prevented from cross-examining, nor would I ever suggest that. They can cross-examine on evidence and on material that is relevant to the direct examination, but they cannot go beyond that. And that's all we're saying. They could certainly make every inquiry they want as to whether or not Mr. Bosco was assured that the person he was talking to was a police officer, that he knew he was a police officer. That's an issue, and there would be no objection. The question is the identity of that person. And we have told Mr. Bosco and his counsel, and Your Honor, that for the purpose of this witness, we are not going to make that inquiry. So the arguments made by Mr. Goldberg in that regard are without merit. The second argument, that it's hearsay, is an argument that the court addressed and dismissed, I think, very quickly, and that is this is not being offered for the truth of the matter asserted, quite the contra. It's being offered to show that it was not true, and it was put out as some type of disinformation to show that there was, in fact, a match when Ms. Clark told Your Honor in court there was no DNA match. And then the next day that was reported by reporter Savage, that there still was a match, and that was still coming from a reliable source. And our intention now is to demonstrate to the jury, for their consideration, the following facts. That prior to any DNA analysis, a member of the Los Angeles Police Department who had previously had contact with Mr. Bosco, who had previously given him corroborative information, and information reliable enough so that Mr. Bosco would go ahead with this story, was told, according to Mr. Bosco, that the evidence on the sock of blood was a match. And that's what he reported. We know that was not true because Ms. Clark came to court the very next day and on the record told Your Honor that was not true. There was no DNA match since no DNA testing had taken place yet. That night, again, after the court made a very stern admonition and made its feelings known that there had been no DNA analysis, that reporter Savage again reported that story. This is something now for the jury to decide, was this a self-fulfilling prophecy on behalf of the Los Angeles Police Department, who gave this information, we know, to Mr. Bosco, and hopefully we will be able to show with the court's concurrence that this officer also gave this information to Ms. Savage. And that is something for the jury to consider. It is relevant evidence. It is highly material evidence. It is not covered by any privilege. Mr. Bosco is not going to assert any privilege, nor could he under the law. It's not that he's waiving anything. It is that if material is already published, it is not covered by the Shield law. The Shield law protects areas that have not been published. That is the very essence and purpose of that rule. So I think on every issue, it is very clear that the material that we seek is relevant, that Mr. Bosco will testify to it, that we will limit our testimony so that he in no way is being asked to invade any privilege of confidentiality, and that the jury will then have relevant information before it to make a determination in this case. Thank you.
Ms. Osinski, do you have any brief response?
Yes, Your Honor. Actually, Mr. Sullivan was prepared to argue this motion, and we were told that we would be arguing before the court at 4 today, and he's on his way here. I feel this has been sort of sprung on us at the last moment, and I want to reiterate that Mr. Bosco will invoke the Shield law as to any unpublished information. And I'd like to clarify something that Mr. Shapiro said. It's not areas of unpublished information. It's or areas of not covered by published information. It's actual unpublished information. The only thing Mr. Bosco will testify to is the accuracy of that article. He will not go beyond that article, and he will not identify his source. It's a confidential source. I believe there's a declaration before the court that accompanies our motion that indicates that. The Shield law will apply, and if he is asked any questions on cross-examination or any questions on direct examination by the defense on any matter that is not specifically stated in the article, he will invoke the privilege. And I think we're going to get into a little bit of an issue as to whether, he can be forced to testify on those matters. And I think it's better to be resolved out of the presence of the jury than to put him on the witness stand and get into this in front of the jury, because I do believe there's going to be a problem. His testimony, we argue, is very limited and very restricted, and I agree with Mr. Shapiro in that he cannot move to quash the subpoena based on published information, and he will testify as to that, but that's very limited. And certainly what we've been advised is that he would be only asked about questions with regard to a particular paragraph in that article. Now the prosecution indicates that they may be going into other areas of that article, and it might involve opinions and conclusions. And, Your Honor, that's a whole nother issue. As to, they cannot go into, they can go into it. We would have Mr. Bosco invoke the Shield law as to the basis for forming some of his opinions or his conclusions, or how anything that related to any conversations and contact they may had with any persons in the article that's not expressly stated in the article. And I think it's fine for Mr. Shapiro to say that he's going to limit his questioning or to published information. However, that does not take into account what the prosecution may do, or if Mr. Shapiro feels that based on a certain answer, he might want to go delve further into the article and into matters that are not published.
All right.
And, Your Honor, if I may just briefly ask that we be allowed to present a full argument on this issue at 4 o'clock when originally scheduled.
You don't think that was sufficient?
Well,
Are there any issues or defenses other than the Shield law that you can raise to non-published information?
well, there's the First Amendment, Your Honor, but I'm not prepared to discuss that at the moment because, as I say, Mr. Sullivan was preparing the argument in this matter, and I was not.
All right. Well, I wish you had told me that you wanted to reserve that right rather than talking to me for the last 10 minutes and then
Well,
telling
Your
me
Honor,
you want to
I
argue
was simply
again.
advised that Mr. Shapiro was discussing Mr. Bosco's
No, you should have started
testimony.
your comments by asking to continue the matter for hearing until 4 o'clock. That's how we should have started the conversation.
Well, I apologize to Your Honor for that. I find myself in the middle of something, and I do apologize, but I believe Mr. Sullivan can better present the issues. He has been preparing to do that.
All right. Well, don't misunderstand me, Ms. Osinski. You and Mr. Sullivan have appeared in court with very short notice, and I understand your need for time to prepare. But since now I'm going to have to hear these arguments twice from Mr. Bosco's counsel. All right. I agree that Mr. Sullivan, if he is the person who's prepared for the argument, I'll hear his argument at 4 o'clock since that was the time originally scheduled. Let me tell you what my tentative ruling is at this point. I'm going to allow Mr. Bosco to be called for the purposes of a 402 hearing, a foundational hearing, determine, one, whether or not he is somebody who is covered by the Shield law. That has to be established for the record. Then the discussion as to what it is the defense wishes to glean from him from that article that he's willing to discuss, and then whether or not either on direct or cross-examination by the prosecution, if the question is asked who this individual was who provided him with the information, if he invokes the Shield law, then I know that out of the presence of the jury. And then I will take this matter under submission likewise with the Tracy Savage situation because we'll be in the same boat as far as that is concerned. All right. Let's take a 15-minute recess and then we'll discuss the Gertie's issue. Might as well use the time. All right. Also in the interim, I'm going to excuse the jury from further service until 9 o'clock tomorrow morning. All right.
Quietly, please.